তাহলে তো
না, যত তাড়াতাড়ি মিটে যাক বাঁচি। একটা না ডিসপোজাল হইতে হইতে আরো 4টা এসে বসে থাকে, ঝামেলা।
ইউটিউবে হাইকোর্টের চ্যানেল থাকে, চ্যানেল ক্রিয়েট করা।
ওদের একটা
judge.
Friday was fallen ill at the of mentioning his matter is already enlisted today in 56. He is now in Neutia, a ICU, and supposed to be transferred to Vedanta. In this circumstance, he has a petition for extension. If it is maybe considered,
57.
he is 56. He is for petitioner. Can is already filed. Can one.
Who is on the other side?
I am appearing the opposite side.
Okay. When is the extend order of stay going to expire?
Expire last time. Once he will give us name.
Okay. Take it now. Only for extension.
Only for extension.
চারটের সময় দেবে 4 p.m.
Rashid, may I permit to mention a matter?
At 4 p.m. you come. at 4 p.m.
May I mention a matter, Lordship, FMAT MD Act, Lordship, same cases,
Huh.
inclusion in the list, Lordship, admission of hearing, Lordship.
Admission.
Yes, Lord.
What is admission?
Yes, Lordship.
What is to be admitted?
What is the
Lordship, claim cases, Lordship.
In claim appeal, admission hearing is there. You will do admission hearing in claim appeal.
Yes, Lord.
No admission is required, sir. If it is within time and form, it will be admitted and
Not within time,
notice
Lordship,
will be-
can application already by section 5 already filed, Lordship.
Section 5. I tell that.
Yes, Lord.
Section 5 serve notice.
No,
You have
Lord.
been directed to serve notice.
No, Lord.
Section 5 is there. What is to be done? There are so many matters. You know, have been before the next available circuit.
Lordship, kindly consider for inclusion in the list, Lordship.
I cannot take it up. No? How many matters are there in claim appeals? 20 matters. Claim appeal.
Lordship, may I permit to mention one matter for extension of interim order, Lordship.
Extension, which one?
Lordship, CRR 40 of 2023. Lordship, it is not in the list. I am mentioning today, Lordship.
Mention before next circuit.
Lordship, interim order already expired, Lordship. Kindly take a.
If it is expired, then next week the next circuit will come.
Lordship,
Yes.
only 5 minutes will take,
No.
Lordship.
Lordship, may I please permit it to mention one matter?
Lordship was passed this order CRS 184/23 and it was taken with my lord. The case number of the code below CR case number 304 2014 has been instituted instead of 2012. CR case number 304 2012. Tomorrow is the date is fixed for code below.
কালকে রাখুন to be mentioned. Where is the copy of the application? Revisional application.
I did not spot of it.
So that where is the mistake? If in your application there is a mistake, how can I put it in to be mentioned? Get the copy of the application, then mention. You have the copy.
I did not change to them.
Can you get it by half an hour? You get the copy of the application.
Is at my chamber at Siliguri.
To be mentioned, the
Lordship,
to be mentioned.
Lordship, may I permit to mention another matter?
Tomorrow to be mentioned.
Lordship, may I permit to mention another matter, Lordship, for hearing, Lordship. Criminal revision and matter, Lordship.
Next, sir. Next, sir.
Lord, may I be permitted to mention one matter? Has been amicably settled between the parties pending a direction from your Lordship.
Huh?
It has been amicably settled between the parties.
What is this FMAT?
Claims case. For inclusion in the list.
Not inclusion. Go to Lok Adalat.
Lordship, for
Mention
that,
before the next circuit.
that direction is.
Go to
I have
Lok Adalat.
already notified the other side and he has put his endorsement.
Huh?
I have already notified the other side and he has put his.
No, you settle the matter before the Lok Adalat.
It's from 2020.
This before the Lok Adalat. Why you are insisting upon filing, passing order of settlement by this court?
A direction is required from your Lordship so that
Why?
the record may be transferred.
Register will go. Register apply করলে হবে. When is the next Lok Adalat?
9th September.
9th September, next month.
Lordship, may I please permit it to mention one matter?
My lord, with regard to item number 17, my lord, kindly may I leave to mention my lord, item number 17.
Item number?
17, my lord, 17. My lord, this,
কি কোনো application করেছো for mentioning?
my lord, may I leave to mention?
Item number 17, it's not in the listed in the email. Have you applied for mentioning to?
No, my lord, item number 17, may I leave to mention for, I need some time because a settlement is going on between the parties. So kindly adjourn the matter.
Sir, is this the process, sir? The e-mentioning is being called, you get into the list and mention that 17 will be adjourned.
Sorry, my lord, I'm sorry.
My lord, may I please permit it to mention one e-mentioning serial number 1 and 2, my lord?
Let us call the e-mentioning.
Mentioning item number 1 and 2.
My lord, I am appearing for the petitioner, my lord. My lord, in this matter, two CRR were filed, CRR 196 and 197 of 2023 before the principal bench when the circuit bench was not available. So, my lord, the Honorable Chief Justice ordered to transfer all the files of circuit bench on 28th of July, but the file is still not received in the Jalpaiguri bench, my lord. And my client is suffering, my lord. There is an interim order prayer also. Police is disturbing him. This is a civil matter and police has given a criminal color. It's a commercial transaction matter.
Who is representing you over here?
My lord, I am appearing on online, my lord. There is no one representative over there.
Court officer, I need to take a note of it and give it to the registrar. It's a function, it will be intimated to the registrar for calling for the records if not received.
My lord, may a date may be given, my lord. My client is suffering, my lord.
Without the record, no date can be given.
My lord, I will try to locate the file and apprise the court officer, my lord.
Who is the advocate on record before the circuit bench?
My lord, I am the advocate in record.
You are the advocate on record in circuit bench. Anybody is appearing on with you?
No, my lord, I am appearing solely, my lord. Solely, my lord.
Okay.
Kindly, my lord.
We'll see, sir. This is the administrative function. I'll talk to the registrar. Yes, SEO. You talk about
Grateful, my lord.
1 and 2, whether these records has been received. Okay, sir. Thank you.
Grateful, my lord. Grateful.
My lord, I have what?
Mention the case number as 304. Actually, it is the service copy.
Well, Puresh. Keep it 14. If you quote wrong number, I will present wrong number. Sir, so that you have need not to come and mention for to be mentioned, I have corrected the thing. Your cause title is wrong. You have mentioned the wrong number. In the order, I have given the correct number. The CR number is of 14. What is the number?
It is actually the brief of Mr. Sudipta Majumdar.
So you are moving. I have shown you the CR case number. What is that?
2014.
What is the correct number? You find out what is it, 12 or 14? Do you know, give you a brief, copy of the brief.
14 is correct one.
14 is correct.
Yes.
বলুন তো ঠিক করে আবার মেনশনিং করুন all along it is 14. Okay, এই দেখো
Mention.
this is the number. You take out an application before the next circuit bench to correct your application. And there is a wrong number mentioned of 12.
Lordship, may I permit it to mention?
Four claim cases are there. Only on the
Next
ground.
one,
Only on the
next
ground.
Already there are so many cases.
Actually, only on the ground of future pursuit and interest.
Cannot be taken, you also know that. Mention before the next one.
My lord, I have filed the FMT appeal. And on behalf of the insurance company.
Huh.
In the meantime, acquisition case has already been filed before the London court. So, my lord, I pray for stay for mention.
Stay.
I am ready to deposit the entire amount.
I don't know if it is listed, I don't know whether it will be taken in the circuit or not. How many matters are there?
3 matters. Otherwise, bank account of the insurance company will be attached.
What were you doing on this? What happened in the previous week? Why didn't you mention? Have you taken up the matter for still?
It was mistake on.
I don't know, it will be listed, but I don't know whether this will be taken up in this circuit or not. Didn't- All the list.
Item one,
One.
My lord, in item number 1, I am appearing virtually, my lord. My learned colleague, Advocate Mr. Bhaskar Das is present to assist the Honorable Court, my lord, physically. My lord, this is an quashing application with regard to.
His right is there.
My lord,
Yes. Because submitted the case diary earlier was produced. He had to produce the case diary. Short passover. And who is for opposite party? All have been served.
Yes. That is already recorded.
yes, my lord, the opposite party was served. The opposite party, the affidavit of service is already before the record of the Honorable Court, my lord. This is not appearing for the first time. This appeared also previously.
It is recorded in the order.
In the previous order sheet passed by this Honorable Court, their appearance has already been, it is already recorded that service was complete, my lord.
Report submitted by.
What service coach? You got no service coach.
My lord will find from the order passed dated 24th March 2021, my lord, it has been recorded that none appears for the opposite party and state despite copy of the application being served upon the state. This has been recorded in the order dated 24th March 2021.
What about opposite party number 2?
And my lord,
What about opposite party number 3?
opposite party number 3, my lord, Mr. Devashish Sinha, learned advocate, was representing, my lord. This his presence is also recorded in the order dated 24th March 2021, my lord.
21.
24th March 2021.
Let the CD come, pass over. Pass over. Yes. Passed over.
item two,
Two lordship.
I'm for the state.
I'm for the petition. Lordship, we have filed an application under section 42 for quashing. Both the parties have mutually settled amongst each other. And we have solved the copies.
Lordship, I brought the office party number 2, Lordship, there's a compromise petition has been filed for.
Your opposite party number?
Office party number
200.
2. Office party number 2.
2. Who is 3?
No, there is no 3.
Take both.
No, 3. There is a petitioner.
My lord, in this case,
No,
charge
Office
sheet,
party number 2.
initially the case was started under section 341, 323, 506, 509, 34. Read this section 25, 1A and 27 of the Arms Act. And charge sheet has been filed and that Arms Act is not there. Now they have settled the matter, it's up to the parties.
Where is the FIR?
Lordship,
Where is the copy of the FIR?
copy of the FIR.
Petitioner from the.
It's given. It's given with the petition, Lordship.
Page number what?
Page number 4.
That-
4. Five.
This is supplementary.
See?
Who is Manju Devi? You have the case diary?
No, I don't, having the chart, copy of the charge sheet, they have annexed, but case study is not.
The supplementary, in the supplementary affidavit, the file the charge sheet has been annexed.
In the application file?
In the supplementary affidavit.
State is directed to produce the case diary on the next date fixed. Where is your client?
Well, I have to check the minute. I was late a little bit, there was a traffic jam in the road, so I'll just check, then pass over the matter. In one case, CD has come, that is item number 30. But in these two cases, I'll just check.
Who is the complainant?
Complainant. Complainant is Mr. Damodar. Damodar Tiwari.
Manju Devi is the wife of Damodar Tiwari.
Yes.
Filed application. $509 is compoundable. 509.
Yes.
509.
Yes, my lord. Yeah. 320 table A, last one, my lord. The woman whom it was intended to insult or whose privacy was intruded upon. Well, let's say.
Table 506. Yes. Manju Devi. File application. File an application. Ask your client to remain present. Manju Devi.
সময় আছে পাঁচ সময় মহিলাকে আসতে হবে লেডি হ্যাজ টু কাম একটি ওমেন it was intended to himself so
Manju Devi. Wife of Damodar. Ask the complainant and his wife to remain present and file a joint application. Okay. Mr. Rajesh. Oh,
my lord one indulgence
madam.
my lord her daughter was also there my lord in the as per the FIR wife and daughter
Previous order was there.
no daughter my lord the complainant they stated that one Manas Gupta resident
Oh, the abusive language was used against the wife
my
and the
wife
daughter.
and daughter so both of them have to be application by all the victims as well as the complainant also. Complainant is a victim, but even then other victims, all the victims.
Yes, Mr. Dhar. Ask the wife and the daughter of the complainant to remain present and not file a joint application that it has been compromised.
Just to kindly to the matter, the next circuit, I will, in the meantime, I will make an application to the defendant and.
Mr. Rajesh Kumar Sharma, learned advocate for the petitioner, submits that the matter has been amicably settled out of court. Mr. Devorshi Dhar, learned advocate for opposite party number 26, accommodation to take appropriate steps. Sorry, submits for fixing the matter. Submits for fixing the matter before the next available circuit bench, so that in the meantime we can take appropriate steps. With the matter in view of the aforesaid submissions made on behalf of opposite party number 2, let the matter appear before the next available circuit.
Obliged.
At item number 3. Item number 3, my lord, I am appearing for the petitioners, my lord, virtually, my lord. My lord, but this is an application, my lord, with a prayer, my lord, to transfer the case, my lord, from the additional chief judicial magistrate to my lord court martial, my lord. My lord, the petitioner is an army personnel, my lord. My lord, he is a sepoy in the Indian Army, my lord. My lord, he was arraigned in a case, my lord, under section 406 and 420, my lord. But my lord, the petitioner, my lord, seeks, my lord, to invoke the provision, my lord, under section 475 of the Criminal Procedure Code, the delivery of the commanding officer of the personnel liable to be tried by the court martial, my lord.
Sir, notice.
My lord.
This is an application for transfer of the criminal proceeding being GR case number 2515 of 2022, arising out of Shamuktola PS case number 294 of 2022, dated 6th November 2022 under section 406/422 of the Indian Penal Code, pending before learned Additional Chief Judicial Magistrate at Alipurduar. Petitioner is directed to heard learned advocate, heard Mr.
Brotin Kumar De, my lord.
Rutin Kumar De, learned advocate on behalf of the petitioner. Petitioner is directed to serve copy of this application upon the opposite parties through registered speed post with the acknowledgement due and file affidavit of on the returnable date.
My lord.
If the matter appear before the next available circuit bench.
Obliged.
My lord, item number 4, I am for the petitioner. I am appearing virtually, my lord. My lord, am I audible?
Yes, yes.
My lord, I'm grateful to your lordship. My lord, in this matter, I have challenged an ex parte order of maintenance passed in favor of the wife. My lord, there is a delay of about 75 days. I have filed a CRAN application along with. So, my lord, if your lordship directs me, let me serve the application under section 5 upon the opposite party and my lord come back. My lord?
Yes, yes, possible.
My lord. My lord, the main revisional application is against an ex parte order of maintenance.
Disposed of.
My lord?
Finally disposed of. Miss
My
case.
lord, it has been finally disposed of.
Interim order.
My lord? It is not an interim maintenance, it is a final order of maintenance.
Order passed ex parte.
Ex parte. And my lord, in preferring this
revisional application has been filed under section
25 days.
2 of the Criminal Procedure Code, challenging an order dated 25th August 2022, passed ex parte by learned Additional Chief Judicial Magistrate Din Hata in connection with Miss Case number 48 of 2019 under section 125 of the Criminal Procedure Code. Mr.
My lord, Ongshuman Chakraborty.
Onsuman Chakraborty, learned advocate for the petitioner, submits that delay of how many days?
My lord, 75 days as per my calculation.
Referring application. As filed an application for confirmation surgery plan 1 of 2023. Petitioner is directed the copy of the application for completion of upon the acknowledgement due and file affidavit of service on the returnable date. Available circuit bench.
I'm grateful to your lordships.
Item 5.
Lordship, in this matter, I am appearing for the petitioner. Last occasion, there was a direction to serve notice upon the opposite party. The notice has not been served. Lordship, kindly take it up before the next circuit.
Issue. Not complied. So notice of the opposite individual next date of hearing which people, Mr. Anirban Banerjee, learned advocate for the petitioner submits that the service of notice upon opposite party is yet to be made in compliance to order. Is yet to be made in compliance to order dated 1st August 2023. He submits for fixing the matter before the next available circuit bench. In view of the above, let the matter appear before the next available circuit bench. Petitioner is directed to comply order dated 1st August 2023 in the meantime. No. Yeah, the copy last. Don't copy. This is section 5 application. Not to.
Item 6.
Lordship, I am for the petitioner for the state. Lordship, let the matter be fixed on next circuit. As senior is out.
You are for the state.
I'm for the state. Petitioner.
You are for the petitioner. not
Yes,
the-
Lordship.
Oh. Mr. Rajesh Singh, Rajesh Kumar Singh.
Sharma.
What is your name?
Sharma.
Rajesh Kumar Sharma,
Yes, Lord.
learned advocate for the petitioner, submits for fixing the matter before the next available circuit. Mr. Shoro Ganguly, learned advocate, appears for the state. Who are the other opposite party? Only state is the opposite party.
State is the only opposite body, Lordship. It's a forest case.
It the matter. In view of the submissions made on behalf of the petition, will the matter appear? Yes.
Grateful, Lordship.
Grateful, Lordship.
Item 7.
My lord, for item number 7, Mr. Sudeep Go is appearing on behalf of the petitioner. My lord, due to his illness, he did not appear. My lord, kindly fixed it in the next circuit, my lord. My lord, on the due to his illness, my lord, copy has yet to be served, my lord, to the respondents, my lord. My lord, I'm praying for kindly make it not next circuit, my lord. So in the meantime, we can serve the copy to the respondent, my lord.
What is your name?
My name is Sandeep Gohara, my lord.
Learned advocate for the petitioners. Madam. Submits that. Informs secretly that advocate on record for the petitioner, Mr. Sudeep Guho, has not come to court due to illness stop. He submits for fixing the matter before the next available circuit. You are appearing for the state?
For the state, Your Lordship.
Mr. Suensu, learned advocate, appears for the state. Petitioner directly serve copy of the matter. Grand restore.
Grand already disposed of.
Grand application already disposed of. But main petition application has not been served.
Yes.
Petitioner directly serve copy of the revisional application. Notice for it. Notice. Along with copy of the revisional application upon the opposite parties to register speed post with acknowledgement due and file affidavit of service on the return. Grateful. Let the matter appear before the next available circuit.
Item 8.
My lord, I beg to appear on behalf of the petitioner, my lord.
Who is for the opposite?
My lord, initially, my lord, the petitioner has lodged a complaint against the opposite party number 2 and 3 for causing house trespass and removal of certain documents of the Anjuman Islamia Society, my lord. My lord, subsequently, GR case was started and charge sheet has been filed under sections, my lord, 448, 380, 383, 4778, 506, and 34 of the Indian Penal Code, my lord. So, and thereafter, trial was started. My lord, the learned Chief Judicial Magistrate Darjeeling was pleased to pronounce a judgment of acquittal without considering the points in the said case, my lord. My lord, challenging.
Serve copy to the other.
Serve copy. My lord, I will be praying for the stay of the judgment, impugned order, my lord.
Why?
My lord, that particular appeal was filed before the learned district and sessions judge Darjeeling. The learned court of district judge, my lord, dismissed my appeal without considering the material facts in the appeal, my lord.
Serve copy.
My lord, stay of the impugned order, my lord, dated 20th October. My lord, stay of the impugned order, my lord. Stay of the order passed by the learned district judge.
Effect of stay of that appeal?
My lord,
If the appeal order dismissal is stayed, then what will be the position of the accused persons?
my lord,
What will be, sir? Clarify. What will be the position?
my lord, because
Without
trial was
behaving
started and
acquitted,
thereafter acquittal.
acquitted.
Trial was started, thereafter there was an acquittal, my lord.
Serve copy to the opposite parties.
My lord, all the opposite parties I said.
All the opposite parties. This revisional application is filed under section 482 of the 482 read with section 401 of the Criminal Procedure Code. Against an order of date against order dated 29th November 2022, passed in connection with criminal appeal number 4 of 2022 by the learned session judge at Darjeeling, dismissing the appeal. Filed against where is the judgment of the trial court?
Milord, the certified copy, Milord.
Trial court judgment?
Milord, that copy has not been annexed, I suppose. Milord, only the appeal and the
What is the GR case number?
GR case number, Milord.
Against
GR case number 67 of 2003, Milord.
GR case number
67 of 2003.
67. GR case number is?
Milord, GR case number is 470 of 2014, Milord. Second line of the judgment, Milord.
In that GR case, the accused persons were acquitted.
Acquitted, Milord.
কি বললাম? Filed against order of acquittal passed by learned Chief Judicial Magistrate Darjeeling. When was the judgment passed by learned Chief Judicial Magistrate?
Lord, that judgment is not annexed, I suppose.
You are not carrying the brief?
Yes, my lord. Only the order of the learned appellate, first appellate court is annexed here, my lord.
Petitioner is directed to serve copy of this application upon the opposite parties. Raised to speak post with acknowledgement due and file affidavit of service on the returnable day.
My lord is making the next circuit, my lord. I'm grateful, my lord.
Madam, for the petitioner, Madam, there's a direction to file the affidavit of service. So this is the affidavit of service. But this is, Madam, the matter for quashing of the criminal proceeding under section 498 a simpliciter. The petitioners before your lordships are the husband, father-in-law and a mother-in-law. My lord, marriage lordship.
For the state,
Yes, your lordship.
who is appearing for the state?
My lord, I have served. Because my lord, marriage in the year 2010. After filing of the divorce suit, matrimonial suit, this 498A proceeding has been initiated at the instance of the wife de facto complainant. Lordship, if your lordship will go through the FIR, such a frivolous FIR, lordship, especially there is no allegations in respect of the father-in-law, mother-in-law. But I think, my lord, for the adjudication, my lord, the CD is required. My learned friend will also agree.
The application for dissolution of marriage was filed, it was not within the knowledge of the de facto complainant. It would have taken any season. What? It was not within the knowledge that an application for dissolution of marriage has been filed when the complaint was lodged. So,
After 9 years.
no copy was served.
After 9 years.
Yes.
Anyway, lordship can.
They have suffered till 9 years.
Lordship
Mr.
kindly.
Chakraborty, state has received the notice.
My lord, yes, state has received.
Where is the case diary?
CD may be called for.
Affidavit of service filed on behalf of the petitioners is taken on record. Mr. Novankur Pal, Miss Sumon Sehanovish, learned advocate for the petitioner, submits that after filing of the divorce suit, the FIR was lodged by the wife. That too after lapse of 9 years. Mr. Novankur Pal, learned advocate for opposite party number. Your opposite party number, sir? 2. 2. She is the complainant, de facto
He is
complainant.
the complainant. Yes, your lordship. Wife de
Submits
facto.
that at the time of lodging of the FIR, the wife did not have the knowledge of the matrimonial suit. May I record your name, Mr. Chakraborty? Should I record your name?
Yes, ma'am.
Mr. Niloy Chakraborty, learned advocate, appears for the opposite party number 1, state. State is directed to produce the case diary on the next date. Let the matter appear before the next available circuit bench. Next available circuit bench.
My lord, there is an order of stay already that is to be, my lord, extended, lordship. Lordship. There is an order of stay, my lord, already granted in the earlier circuit bench. Lordship can. But it is, if your lordship pleases for your lordship, always extend the interim order, my lord, since it has been.
If it has lapsed from it has to be reinforced by filing an application.
Take out an application play before the next one.
Second name.
My lord, item 10, my lord, I am appearing on behalf of the my lord, private opposite party, my lord. Kindly see the order passed by your lordship on last Monday, my lord. Last Monday also, my lord, no one had appeared for the petitioner. We were there and your lordship had given them an opportunity to appear today, but I don't think they're interested to pursue the application. Well, this is an application for transfer, where they have sought for transfer from Siliguri to Hooghly only on the ground of convenience of the de facto complainant. Now, my lord, if your lordship takes the charge sheet at page 37, once, my lord, kindly see the charge sheet at page 37, relevant part at page 38, the list of witnesses. Out of, my lord has got page 38, my lord.
37.
37 is the chart sheet. Kindly turns the page, my lord, comes to 38, my lord. Next page. The list of witnesses, column 14 of the chart sheet. Kindly sees out of 9, my lord, 6 witnesses are, my lord, from Siliguri. And if your lordship now goes back to the FIR at page 22, and the complaint is at page 23 onwards, my lord, the entire incident, the entire allegations, my lord, they have taken place within, my lord, Siliguri. So, my lord, on the point of territorial jurisdiction also, my lord, in terms of 177 of the CRPC, my lord, the courts in Siliguri will have jurisdiction. That is the ordinary territorial jurisdiction, my lord. And, my lord, law is well settled that convenience of a particular party cannot be a ground for transfer, where the other witnesses hail from the local place of occurrence, the local jurisdiction. Kindly sees the FIR, my lord, starts at page 24. The complaint starts at page 24 with "Dear Sir." In the second paragraph, your lordship will see the 4th line of the second paragraph, starting with "I had gone to Bagdogra flyover." My lord has got it. I had gone to Bagdogra flyover and I met him underneath the Bagdogra flyover at about 10:30 a.m. in the morning. Thereafter, he proposed me to marry him. I agreed with his proposal in open heart. Thereafter, the accused person named so-and-so told me to go to his house. He came by one Activa scooty. Pursuant to the said, I went to his house and I changed my dress at the house and took a bath. Thereafter, I had a so-and-so relation with him at his room. I had spent 4 times at his house. Then I left his house and we both went to Panihati and had lots of fun over there, etc., etc., my lord. Now, my lord, the house, your lordship will see, my lord, kindly comes back to page 22, the formal part of the FIR. Where is the petition, the accused person's house? Apornesh Mukherjee of North Bagdogra, Shiv Mandir, Bagdogra, beside North Bengal University, district Darjeeling. This is the place of occurrence. The first place of occurrence is under Bagdogra flyover. And then, my lord, the next is in the house of the opposite party number 2. So, my lord, following 177 of the CRPC, the courts in, my lord, Bagdogra, Siliguri will have the jurisdiction to try the accused. And, my lord, out of 9, my lord, I have shown to your lordship 6 witnesses are from that place.
Okay.
My lord, I am praying for dismissal of this revisional application, my lord.
No, I am issuing admissive notice to the petitioner.
Very well.
Appears on behalf of the petitioner.
Lordship, senior counsel and Sekhar Bose will appear in this case. Only 1 day admonition, Lordship.
Placing it.
My lord, in that case, kindly take it up on Wednesday, my lord.
Not possible. Placing it before the next circuit. Next week, the circuit will be there.
My lord, kindly takes it up, my lord. Twice I have appeared before your lordship for this matter, my lord. And they are only watching, my lord, after so many things, my lord, my learned friend is standing up to say, to pray for time, my lord. He could have said that at the first occasion when the matter was called. He was waiting and watching what is happening.
He realized to make submission.
My lord.
He has realized to make submission.
Well, kindly keep it day after tomorrow, my lord.
Oh no, it will not.
It's a short matter, my lord. I have nothing much to add, my lord.
Mr. Learned advocate for petitioner. Saurabh Chatterjee, learned advocate, appears for opposite party. Mr. Neelal Chakraborty appealed. About the state.
Yes, my lord. Mr. Chakraborty was for the state.
Agenda number 10.
As per the previous order sheets.
I'm recording Mr. Neelal Chakraborty, learned advocate. Submission on behalf of the petitioner.
My lord, one prayer, if I may make, my lord, if your lordship will kindly observe that there is no stay and the trial court is to proceed in accordance with law.
Not required, Mr.
Because here they are not appearing and in the trial court they are paying for time.
But it's not required. Clear.
Mine.
Petitioner pocket yes. Petitioner no?
Item 11.
আজকে এসছে কেন? 9th জন্য দেখি আবার দিলেন order করতে হবে. No order need be passed. Let the matter appear on the scheduled date. 62 note. Case number 62.
Item 12.
Lordship, I'm for the petitioner. It was
Item
this
12, I'm
matter.
taking for not today, my lord. I'll be receiving the LCR today, my lord.
Lordship, practically, LCR, on the last occasion, your lordship was pleased to call for the LCR on the ground when they have filed the charge sheet.
Yes, my lord.
Now,
I didn't receive the LCR. How can
now, on the last occasion, we have miscalculated, and the origin, the certified copy which has been enclosed with this petition, it will reveal that within 3.5 years from the date of offense, that is 1/1/19, the charge sheet has not been filed.
My lord, tomorrow top of the list it can be kept. Tomorrow top of the list, my lord, it can be kept. I'll be handing over the LCR also, my lord, to the court. No, I'm praying for just not today.
Not today.
Lordship, then
I mean,
top of the list.
Top of the list. Top of the list. There are other matters. Take it up. Not today.
Not today, my lord.
Item 30.
In this case, my lord, I for the petitioner, my lord. The victim was assaulted by the opposite party number 2 and 3, my lord, brutally. Victim was brutally assaulted by opposite party number 2 and 3, my lord.
Lordship,
Initial-
will appear in this case. He is suffering for cancer and going for the further treatment, Lordship. I am seeking for next circuit, Lordship.
I'm for the state CD, I'm holding the CD. This case actually what happened, my lord, initially the case was started under section 279, 341, 325, commencing all available sector. The accused were arrested and they were told bail was granted. And later he just victim he succumbs to his injuries and after 4 days he expired. So section 304 was added. Now they appeared in the court, they have not absconded, they have whatever the order was, they have complied with.
Well, may I
On that
place my
day,
case, my
they
lord?
filed an application for cancellation and that was not cancelled, the bill was not cancelled, though the section 304 was added. And the bail, the confirmed bail was converted into an interim bail. So now I don't find any wrong in this order.
My lord, there's a specifically illegality in the order, my lord. There's a specific Supreme Court judgment, my lord, reveal that, my lord. May I place my case, my lord?
No.
May I place my case, my lord?
Asun.
My lord, may I, my lord? My lord, kindly see this, my lord.
Orijit Ghosh. When will it come?
Next circuit, my lord. Actually, further bleeding was happening from her mouth.
Mr. Orijit Ghosh.
On the infection. On of the
Refuse for the petitioner. But a question will crop up in this particular application that whether exercising a revisional jurisdiction, the court can cancel the bail when there is a separate chapter concerning the cancellation or grant of bail in CRPC.
I am not paying cancellation of the. I am paying on the. I am paying challenging the order of the CGM. I am. Let me complete. This is not the cancellation. This is not the cancellation. What I am paying, the learned court below, granted, the initially, the bailable section was given, subsequently, he died, and the cancellation of prayer, cancellation of bail prayer made by the IO. And cancellation, 304 added, subsequent cancellation of bail prayer was made, cancellation of bail prayer, the prayer was not allowed, subsequently the bail, which was the regular bail, it was converted to that interim bail. Specific judgment in this case, I have come before your lordship.
I have asked you this interim bail. You are agreed by the interim bail granted by the court.
Look, this is
try to clarify.
I'm answering
question. What is the interim bail? You are agreed by the interim bail granted by the court. Are you agreed by the interim bail granted by
yes,
the
your
court?
lordship.
Try to please answer.
Yes, your lordship.
Now, what is your prayer with revisional application? My question is, in the revisional jurisdiction, whether the court can exercise in cancelling the interim bail.
The order itself is bad, my lord. Order itself bad, my lord.
What is the good order?
My lord, kindly see, my lord.
Mr. Purijit Ghosh, learned advocate, appearing for the petitioner, submits that after
My lord, these cases are already specifically deal with it, my lord.
grant of keep it. After addition of 304, the learned CJM converted the bail earlier granted into
Yes.
an
Standard
interim,
7 bill.
which is bad in law. You are Mr. So-and-so learned advocate submits that the conducting lawyer, Mr. Arnold Saha, has not come to court due to his medical treatment. Mr. Niloy Chakraborty, learned advocate, appears for the state. In view of, you are for opposite party number? 2 and 3. Opposite party number 2 and 1. In view of submissions made on behalf of opposite party number 2 and 3, with the matter, when you return?
Maybe next week.
Next week. Let the matter appear before the next available circuit bench.
Yes, my lord.
Item 40.
My lord, I am appearing for the petitioner. My lord,
Where is your copy?
my lord, I have served it, but they are yet to receive. If my lord wishes, I can make my hearing.
No, you have to complete the service.
No, my lord, service is not yet completed. We have dispatched the
This is under my lord.
is dispatched, but they haven't received.
Mr. Swatarudrio Mukherjee, learned advocate for the petitioners, submits that the service upon the opposite party number.
Yes, my lord.
Opposite party number.
Opposite party number 2.
2
De facto complainant.
is not yet complete. Mr. Ujjal Luksam, learned advocate, appears for opposite party number 1 state. Petitioner is directed to serve notice upon the opposite party number 2 afresh to registered speed post with acknowledgement due and file affidavit of service on the return. Let the matter appear before the next available.
My lord, let the case diary be called for.
State is directed to produce the case diary on the next date.
Fiction next circuit.
Highly obliged.
Next circuit.
Item 18.
Lordship, in this matter, I'm praying for next.
Now for the state matter, I'm holding the CD.
Praying for next.
It's a very
On
simple.
the last week, everybody was pressing to get
my
their date
dear-
fixed on 7th, 8th.
When CD is produced, they're taking time. Madam.
I need to take some instruction, Lordship.
Yes, the ground. But I feel, my lord, it's not mentioned. Once they have filed the application. with due
Lordship, I need to
respect-
take some
with due
instruction,
respect to
Lordship.
My
Kindly make it next.
learned friend, their thing is that there are cause of action of 2 police stations. The petitioner, the de facto complainant used to stay in Jaigaon, and in matrimonial, his house was in Jalpaiguri. So these are the allegations, the entire torture happened in Jalpaiguri, the most of the part of the torture, and a part of the torture happened in under Jaigaon police station. So she has filed a case complaint before the Jaigaon police station. Now on that ground, they have come for torture. It's a case of 198. Just dragging the procedure, nothing else. It's very clear in the CRPC. Even in a part,
12 weeks are further on.
it's a continuing offense, 498A. Just কতদিন টানবো বলতাম সিডি নিয়ে আসলে আমার নিচে সিডি গান করবো
Yes, Mr. Banerjee.
Lordship, I'm praying for next.
Yes, so these are the cost, my lord, the legal.
Mr. Banerjee, Animal Manager, Leonard Advocate for the petitioner. Submits that. Submits for accommodation. Accommodation submits for placing the matter before the next available circuit bench. For taking necessary instruction from his clients. Mr. Niloy Chakraborty, learned advocate, appears for the state. Did the matter appear in view of the submissions made on behalf of the petitioners? Let the matter appear.
Deep look.
Item 16.
Madam, for the petitioner, madam. In this proceeding, I'm praying for quashing of the criminal case
Who is for the
initiated
state?
against the bank officer while performing his duty. The recovery proceeding was going on. While performing his duty, this criminal case has been lodged, madam, against the present petitioner, madam. But there was despite instituting proceeding under the SARFAESI Act, the bank has also initiated proceeding under the Recovery Act, my lord. This criminal proceeding has been initiated, my lord.
When was the case start under section under the SARFAESI Act?
My lord, page 29 is my original application before the Debt Recovery Tribunal.
Twenty-nine.
29 onwards, my lord. This is under section 19 of the Recovery of Debts and Bankruptcy Act 1993, my lord.
Oh, you are for the bank?
Yes, my lord.
Now against the bank authority, who is Gayatri Saha?
She is the complainant, my lord. What happened? Shahab Auto Private Limited. If you also kindly comes to paragraph 8, where I've stated through one of its director authorized in that respect and pursuant to an application dated 27th January 2016, State Bank of India sanctioned 2 cash credit loan facilities for a sum of rupees 3 crore. Malad. Thereafter, after his death, his son Deepak Kumar Saha and Devjyoti Saha, being his legal heirs and representative.
Para 8 of where only?
Para 8 of my petition, Malad, revisional application, this quashing petition, Malad. If you also wants to, yes, I can show from the original application also.
Para 9, yes. Got you. Page 7.
Yes, page 7. Well, thereafter, his legal heirs have executed various documents, including arrangement letter dated 16 February 2016, an agreement of loan cum hypothecation dated 16 February 2016, and stood as guarantor along with others. The loan thereafter, next page, the request of the request of the borrower, sanction limit was enhanced to 4 crore 40 lakhs, my lord. And thereafter it was reduced to 3 crore 50 lakhs, my lord. Thereafter, on the ground of default, the accounts were declared NPA with outstanding loan of rupees 3 crore 90 lakhs 48,223, my lord.
This is the amount that has been given in the proceeding in the service here.
Yes, my lord.
This amount 3 crore 90 lakhs is the outstanding.
Yes, my lord.
When did you file that proceeding before the surfacing?
Yes, my lord. My lord, it was filed in the year 2021, my lord.
No, date.
My lord.
What is the case number? You have mentioned the case number.
Yes, my lord. Case number
OA
29 90 OA 91 of 2021. And this instant complaint was lodged in the year 2022, 28 July 2022. After receiving the notices under section 13 to 13(4) of the Surface Act, my lord.
July 20. They have appeared before the.
Yes, they have also preferred an application under section 17 of the Surface Act, challenging the notice under section 13(4), my lord. And my lord,
in this proceeding itself?
No, not in OA. They will be OP. They have also initiated separate proceeding under the Surface Act, my lord, challenging the notice issued by the bank, my lord.
Who is Gayatri Saha?
She is the wife of the original borrower.
Means father of Deepak.
Yes. And now, my lord, the property has been auctioned, my lord. Already auctioned. Or if you also kindly comes to.
So what is
the
the
notice.
allegation of forgery?
If you also kindly comes to the complaint.
The documents of the bank has been challenged that these persons have forged the bank documents. That is the allegation.
That is the allegation, my lord.
Okay. Yes, next.
Yes, my lord. She also lodged a civil suit, my lord, which was dismissed, my lord. Page 282, my lord.
Title suit 55.
Title suit 55. Page 282. That has also been dismissed. Prior to lodging this instant complaint, my lord. But she has not disclosed that.
What was the civil suit? Injunction.
Injunction, my lord. And my lord, page 279 is the notice for auction, my lord. 279. The property has been auctioned, my lord. Thereafter. Now I'm praying for quashing the proceeding since while performing his duty, he has taken steps on behalf of the bank. Hence, I'm praying for stay of the proceeding, my lord.
Stay.
হ্যাঁ তো মোশন স্টেজ আছে তো, মোশন স্টেজ আছে তো। হ্যাঁ হ্যাঁ না না স্টেট বলেনি, স্টেট।
This revisional application has been filed under section 482 of the Criminal Procedure Code, praying for quashing of proceedings, being GR case number 1259 of 2022, arising out of Kotwali Police Station case number 843 of 2022, dated 28th July 2022. Under sections 467, 468, 471, 420, 403 of the Indian Penal Code. Pending before learned Chief Judicial Magistrate, Kuch Bihar. The brief fact of the case is that Saha Auto Private Limited, through one of its directors, approached the State Bank of India, which is the branch, sanctioning branch, State Bank of India, Siliguri. Siliguri, underline to change. Siliguri branch, which sanctioned two cash credit loan facilities of a sum of rupees 3 crores against equitable mortgage by deposit of title deeds.
The Kuch Bihar branch, madam.
Kuch Bihar,
Kuch Bihar.
State Bank Kuch Bihar branch.
Okay.
কি বললাম? Equitable mortgage by deposit of title deeds as security. Stop. Security. ACCU. After the death of Dilip Kumar Saha was one of the directors.
Yes, ma'am.
One of the directors, namely Dilip Kumar Saha, his sons, namely Deepak Kumar Saha and Deep Jyoti Saha, along with others, executed various documents, including arrangement letters and agreement of loan cum hypothecation on 16th February 2016, and stood as guarantors along with others. Stop. On the request of the borrower, sanction limit was enhanced to 4 crore 40 lakhs. Then again it was reduced, and thereafter it was reduced to 3 crores 50 lakhs. Stop. The borrower failed to clear the outstanding loan, and consequently, credit facility was withdrawn on the ground of default, and the account was declared non-performing assets within bracket NPA. The State Bank of India Stressed Assets Recovery Branch Siliguri initiated proceedings under section 19 of the no,
Bank of Israel is criminal case. Huh?
Before the DRT, what was the section and the act under which the process was initiated? It was section 19 of
OA 90, no, OA 91. OA 90.
No.
Huh?
What is the proceeding before the DRT Siliguri?
It's a recovery of debt filed by the bank, my lord. Section 19, my lord. For
Section
recovery
19.
of debt and bankrupt under the Recovery of Debt and Bankruptcy Act 1993. It was registered as OA 91 of 2021.
19 of Recovery of Debts and Bankruptcy Act 1993. Read with recovery of debts due to banks and financial institutions within bracket amendment bracket close Act 2000. For issuance of certificate of recovery of a sum of rupees 3 crores 90 lakhs 48,223.50. 223. Before the Debts Recovery Tribunal Siliguri, which was registered as OA 91 of 2021. Notice under section 13(2) of the Surface Act was issued on 8 February 2022. Stop. Notice under section 13(4) of the Surface Act was issued and symbolic possession of the property was taken on 21st April 2022. The borrowers also initiated a proceeding under section 17 of the Surface Act. এই সারফেসি ফুল ফর্মটা দিয়ে দেবেন, এখানে আছে দেওয়া। দেখুন, securitization and reconstruction of financial assets and enforcement. না, এইটা সারফেসি বলে, herein after referred to as in short সারফেসি বলে তারপরে সারফেসি ব্যবহার করবে। কোনো না কোনো জায়গায় একটা করে করবে। Who was the plaintiff in title suit numbers 55 or 2020?
The opposite party number 2, my lord.
The opposite party number 2, wife of late Dilip Kumar Saha, also filed a civil suit being title suit number 55 of 2020. Which was dismissed for non-prosecution. Thereafter, The opposite party number 2 lodged criminal complaint under section 467, 468, 471, 420, 403 of the Indian Penal Code before the Kotwali police station, which is registered as Kotwali PS case number 843 of 2020. Against the, who are the petitioners are?
And the petitioner is the officer of the bank, my lord. Adarsh Modi, my lord. If you
Only one?
This is the formal FIR, my lord.
There is only one accused.
The petitioner
against the petitioner and
the recovery, no name has been mentioned, only recovery officer has been named, and number 1 is Adarsh Modi, my lord. Formal FIR, page 25.
Against the petitioner, who is the regional manager.
Yes, madam. Now he is. He is an officer of State Bank of India, regional office.
Who is an officer of State Bank of India, regional office at Siliguri.
Siliguri, madam.
Siliguri.
Stressed asset and recovery branch.
Being agreed by such proceedings, the petitioner has preferred the present revisional application for quashing of the proceedings. Mr. Novankur Pal, learned advocate for the petitioner, submits that credit facilities were sanctioned in favor of Saha Auto Private Limited upon application by one of its director, and after the demise of Sri Dilip Kumar Saha, his sons executed documents and stood as guarantors to the loan sanction. However, there was default on their part and the account was declared NPA with withdrawal of the credit facility. Proceedings stopped. The bank took up proceedings before the Debt Recovery Tribunal Siliguri and notices under the SARFAESI Act was also issued. Thereafter, the petitioner, who is the wife of late Dilip Kumar Saha, on frivolous and baseless grounds, filed complaint before the Kotwali police station. The entire dispute by and between the parties is civil in nature. And therefore, such proceedings, criminal proceedings, is harassing one. In light of his aforesaid submission, he prays for stay of the proceedings. Criminal proceedings pending before Chief Judicial Magistrate, Kuch Bihar. From the material placed, it is found that Dilip Kumar Saha, directors of Saha Auto Private Limited, availed of credit facilities to the tune of rupees 3 crores. After the demise of one of the directors, his sons executed documents. His sons executed documents and stood as guarantors. It is also found that proceedings were taken up before the DRT Siliguri for recovery of outstanding dues to the tune of rupees 3 crores 90 lakhs. Wait, where is the copy of the notice? Notice under section 13(2) was also
This
issued.
is the possession notice. I've annexed the possession notice, my lord.
13(2) notice?
notice is not here, my lord. But I have the notice of issued for taking possession of the for
13(4) notice.
Not here, my lord. No. But I have the order of the district magistrate who has passed order under section 14 after 13(4) was.
In the ever conspicuous of facts, there shall be stay of operation of stay of further proceedings. Stay of further proceedings. All further proceedings of we can take for a period of 4 weeks or until further orders, whichever is earlier. Parties shall be at liberty to pray for modification, extension, liberty to pray for extension, modification of the order of stay in accordance with law. Petitioner is directed to serve copy of this application upon the opposite parties through registered speed post with acknowledgement due and file affidavit of service on the returnable day. Let the matter appear before the next available session.
On a registered post will take some time. Speed post.
Why?
The
registered speed post. Registered speed post. What is it?
Grateful loss.
Item 17.
My lord, item 17, my lord, I am appearing virtually, my lord. A talk of settlement is going on between the parties, my lord. So what I am praying, my lord, kindly adjourn the matter for 2 weeks, my lord. In the meantime, if it is settled between the parties, then
Yes.
My lord, I'm been led by Mr. Honorable.
Mr. Swensu, learned advocate for the petitioner, submits that a talk of settlement between the parties is going on. He submits for fixing the matter to the next available circuit bench. Let the matter appear before the next step.
Deputy of Life.
Correct. Hey, madam. আপনার এই ডায়েরি যে যেগুলো নোট ছিল 7th সবগুলোর মধ্যে ইনকর্পোরেট করো।
Item 18.
I am appearing through virtual mode, Milord. Milord, can you hear me? Am I audible, Milord?
Yes.
Milord, this is my application under section 482, read with section 401 of the CRPC, Milord. I have come up for washing of the particular entire proceedings against me, Milord. Milord, this has culminated out of a FIR, Milord, which was submitted to the Siliguri Women Police Station on 12/5/2022, my lord. Milord, the allegations, even if it is taken in the face value, my lord, it does not constitute any offense against me, my lord. I have been only enticed because my brother married the de facto complainant or the informant, my lord. My lord, what has happened actually, my brother stays at Singapore. And my lord, I have already attained the marriageable age, my lord. To settle the score between the brother and them, they have entangled the entire family. We do not stay with them also, my lord. And as far as the petitioner is concerned, my lord, she stays at Chennai, a software engineer, my lord. She has got nothing to do with this 498, and the entire thing took place, whatever it is, in Siliguri, my lord. Therefore, my lord, there was no investigation, and the police, after 41A compliance, even has submitted a charge sheet, my lord. Therefore, my lord, the entire proceedings against me, not the entire proceedings against the others, against me, my lord, I have challenged before your lordship.
You are the sister-in-law.
Yes, I am the sister-in-law, my lord, and I stay at Chennai, and they stay at Singapore, my lord.
Your brother stays at Singapore.
And the sister-in-law who has been wedded to my brother, she also stays at Singapore. She used to stay at Singapore. And the entire incident, she narrates that in the wedding ceremony took place between the brother and the sister-in-law at Siliguri, my lord.
Ramesh Kumar Swami, right. No, opposite party number 2 stays where?
Opposite party number 2 at present, my lord.
Yes, yes.
At present, maybe at Siliguri, my lord. It's not known to us. She was at Singapore.
Is the de facto complainant?
This is informant. De facto complaint.
You serve copy upon her and the state.
In the meantime, my lord, I am praying for
Next circuit bench.
a stay as regard myself, my lord.
Serve and then come back. This is an application for application under section 482 of the Code of Criminal Procedure Code, read with section 401 for quashing of Siliguri Police Station. What is W? Woman. W. W. Case number 73 of 2022. Under section 498A, read with section 4 of the Dowry Prohibition Act. Mr. So and so learned advocate for the petitioner submits that the petitioner is a resident in the state of Tamil Nadu and she has got no nexus or connection so far as the allegations disclosed in the FIR. It prays for stay of further proceedings. Petitioner is directed to serve copy of this application upon the opposite parties and through registered speed post with acknowledgement due and file affidavit of service on the returnable date. Let the matter appear before the next available circuit bench.
Milord, in the meantime, stay of proceedings against myself, Milord.
Serve the copy and come back. Next week there will be next circuit. In the meantime, just
Deeply utilized.
Item 19.
Lord, item 19, Lord, may I have your lordship's kind leave to appear virtually, my lord. My lord, I have challenged a proceeding under section 500. My lord, the petitioners before your lordship are the newspaper and the editor-in-chief. Lord, if lordship kindly takes up page 39 of my application once. Lord, kindly straight away come to page 39 of my application, my lord.
Yes.
Page number 39, my lord, will kindly see the petitioner, the accused number 10 and 11 are before your lordship. So 10 and 11, 10 is the newspaper, my lord, and 11 is the editor-in-chief. Now, my lord, kindly comes to para number 9 of the complaint, my lord. That's page number 42 of my application. Para number 9 of the complaint, my lord. Now, the allegations are that there was an incident which I had reported in the newspaper. Now, the incident relates to a person, political person, regarding his involvement in an offense. Now, I had only reported the fact that there is an FIR and investigation is pending. Now, kindly see para 9 of the complaint. Now, that's the only allegation in respect of the accused number 10 and 11 before your lordship.
Accused 9, 10, and 11.
Well, 9 is not the correct nomenclature. 9 is another person. Let 10 and 11 are before your lordship. But after para number 9, if your lordship has seen the para number 9,
Yes, yes.
lordship will kindly come to page number 46, kindly comes to page number 46, this is the initial deposition of the complainant, before the learned magistrate. Page number 46, your lordship come, my lord.
Yes.
Page number 46, my lord, I just placed the excerpt, my lord, of the section 200 deposition. I am the complainant. I am a teacher of such and such. I am doing my job for 22 years. I am a secretary of the walk-off board as appointed by the walk-off board West Bengal. I am also a member of the ruling party. I am also under Tufan subdivision. I am also a social worker and I am doing my work for general people and society at large. I have a good reputation in the society. Accused number 1, Babli Hatin, is known to me since 2012. She was a domestic assistant to my family. I gave all basic needs to her. I also gave her wages after the end of every month. In the year 2017, her parents came to my house and had taken their daughter from my house. And after 2 years, they again sent her to my house as a servant and they demanded more wages from me. On 13/5/2022, her mother along with some other women came to my house in absence of me and they had taken their daughter to their house and demanded 30 lakhs from me. They threatened me that I do not pay the said amount, they will bring a rape case against me. On 28th of May, they initiated a false case under 376 along with other section of IPC against me before Tufanganj PS. On that day, they collected a lot of reporters and displayed the said false incident to public, and they also used other social media like Facebook and other media channels and newspapers to defame me. My prestige was totally damaged. The conduct of social media as well as other news portal, I tried to make the complaint before the local police station, did not give any attention to my prayer. I have no other alternative. I have come up before this court. So this is the deposition of the complainant. Now, the FIR has resulted in a charge sheet. The charge sheet is at page number 53 of the revisional application. Okay, we kindly see the charge sheet. Whatever charge sheet. So page number 53 is the charge sheet. Page number 55 is the brief charge sheet.
Yes.
Now, we'll kindly see page number 52 for a moment. Page number 52. This is the newspaper reporting. On the right hand side, we'll kindly see. Has come to page number 52, We'll kindly see on the right hand side, it is a small column, my lord. Has my lord seen it, my lord? But I don't want to read the whole reporting before your lordship. My lord, we'll kindly see what is written there. It only says that upon an information from the local police station, the newspaper reports an incident regarding this person. And my lord, we'll kindly see in terms of the FOXO Act and other relevant statutory, my lord, we have not disclosed the name of the victim or anything. So it's just a newspaper reporting before on relating to the incident, my lord. On 29th May, this report comes out in the newspaper, my lord. But page number 52 is the newspaper reporting and page number 53 is the chart sheet. So, there is no iota of evidence that this is a false reporting or anything. And more than that, I'm covered under the fourth exception of section 499. If lordship kindly sees the fourth exception of section 499 IPC, we'll see it relates to publication or reporting proceedings. We'll kindly see the fourth exception.
Yes, 499.
499, lordship kindly comes to fourth exception. It starts with the wording like publication of report of proceedings of court. It is not defamation to publish substantially true report of proceedings of court of justice or results of any proceedings. So I have published regarding a registration of an FIR, but there is no opinion of the reporting agency that was there in the newspaper article. It is only relates to registration of the FIR, and lordship has kindly seen the veracity of the reporting as well. The report, the FIR which was reported has culminated into a charge sheet. So that charge sheet has not been challenged or he has not been acquitted of those charges. So it's only a reporting that was there based on which the complaint is registered under section 500. Among other people, I'm not for the other people, I'm only for the newspaper and the editing chief. I'm covered the press count and I'm covered by this honorable court's judgment asking CRR number 573 of 2023.
What is the allegation made? Paragraph 9.
Only paragraph 9. That's the only allegation. Page number 42, if your lordship kindly sees, para number 9. It says, has falsely printed the article relating to the petitioner and assassinated his character by imputing statements which says or reads that the petitioner was on a continuous and regular basis had been taking sexual advantage of the accused number 1. Nothing of this kind is reported, my lord. That the contents of the allegations were printed on the said newspaper on the 29th of May 2022, page number 16, which when circulated throughout the district of Kuch Bihar, tarnished the reputation of a petitioner at large scale and resulted in imputation and defamation of a petition. Well, there's another point which says, which is only the complainant was statement was recorded under section 200. Unless the person who comes up before the court and says, in my eye, the reputation of this man has been defamed, the defamation is not there. So only recording one statement under section 200, the learned violation of the issue process, my lord. But I am challenging the order of cognizance and the order of issuance of process, my lord. This is your lordship.
This revisional application has been filed under section 482 of the Criminal Procedure Code for quashing of proceedings, being CR 55 of 2022 under section 500 of the Indian Penal Code, pending before learned judicial magistrate at Tufanganj. The brief fact of the case is that an FIR was lodged by a victim against the opposite party number 2 complainant. Which was registered as Tufanganj Police Station case number 438 of 438 dated 28th May 2022 under section 376 within bracket 2 within bracket N 500. Where is the copy of that FIR?
Page number 49 of your lordship. Page number 49.
And 506/109 of the IPC. Upon completion of investigation, the investigating authority submitted charge sheet in the said proceedings against opposite party number 2 and one other under section 376 2 N 506/109 of the IPC. The aforesaid fact was published in Bengali newspaper within inverted comma Uttarbanga Sangbad in which the petitioner number 2 is the editor-in-chief and general manager. Thereafter, the opposite party number 2 filed a complaint case and where is the order of issuance of process in that proceedings complaint case? Alleging of offences punishable under section 500 of the Indian Penal Code before the additional Chief Judicial Magistrate at Tufanganj, being CR 55 of 2022. By order number 5 dated 5th September 2022, processes were issued against all the accused persons. The processes were issued, or in the complaint case? দেখুন তো আমি audible হচ্ছে না। Can you hear me, Mr. Huh? Can you hear me?
Yes, my lord, yes.
Is the process is being issued against all the accused persons in the complaint case?
Yes, my lord. My lord will kindly see in view of the sufficient ground to establish the alleged committing offense under section 500 against all the accused person. At page number 47.
Processes were issued against all the accused persons, including the petitioners. Under section 500 of the IPC. Being aggrieved by such proceedings, the petitioners have filed the present revisional application for quashing of such proceedings. Mr. Anirban Mitra, no? Mr. Advocate Mr. Anirban Mitra. Anirban Dotto. Learned advocate for the petitioner submits that the publication made in Uttar Bongo Sangbad has only referred to the facts as per the judicial records. Stop. There are no such publication or imputing statements against the complainant. Referring to exception 4 of section 499 of the IPC, exception 4 Roman, he submits that where a true report of the court proceedings is published, it is not a defamation under the Indian Penal Code. Stop. In light of his aforesaid submissions, he prays for stay of all further proceedings in CR 55 of 2022 as against the petitioners. From the materials, it is found that a criminal case was initiated against the petitioner, against the opposite party number 2 and one other, under section 376 2N/506109 of the IPC. Stop. Upon completion of investigation, charge sheet was submitted against the FIR named accused persons under the aforesaid provisions of law. The matter was published in the Uttorbongo Sangbad. I find that an arguable case has been made on behalf of the petitioners. In view of the above, there shall be stay of further proceedings of CR 55 of 2022, entitled take it from the cost title, as against the petitioners for a period of 4 weeks or until further order, whichever is earlier. Petitioners are directed to serve copy of this application upon the opposite parties through registered speed post with acknowledgement due, and file affidavit of service on the returnable date. Let the matter appear before the next available circuit bench.
I'm grateful. I'm grateful. I'm so grateful for the indulgence.
Item 20.
20 appear for the petition.
Thank you, Mr. Dotto. Thank you. Okay.
In item 20, my lord. My lord, kindly, because this is the matter where I had filed an application under 457 of the code.
For 95,000.
Yes, my lord, grateful. My lord was pleased to direct my learned friend to produce the case diary. My lord. But this is the police report which is filed by the IO to the court below. Madam.
I will give no objection.
Yes, yes, my lord. It is recorded in the impugned order as well.
What was the reason for rejection of this? How do you prove this case?
My lord,
after it is returned, this is a part of Alamat. How do you prove that?
My lord, actually, in the impugned order, my lord, there is no specific ground for rejecting the prayer of the petitioner, my lord. This is a seize of currency notes, my lord. During investigation has been seized, and after completion of investigation, police has IO submitted the charge sheet also, my lord.
No, I am asking you,
my lord,
at the time of trial, when the Alamat will be produced.
Yes.
How do you prove that 95,000? Because
yes,
that
my
is
lord.
the cash.
Yes, my lord.
And it all.
There
So
must,
here's
there may be a direction upon the petitioner that if required at the time of trial, she may be produce the alamat before the court below.
then she will not be able to use that 95,000.
Till disposal of the case.
So what is the use of taking it?
More or less, my lord, this amount which has been, my lord, recovered. This was, my lord, the amount which was stolen from the consideration amount which I had received after selling my land. Now the allegation is not of theft,
You
my
gave
lord.
it to your son who has died.
No,
Yes.
I did not give it to my son.
As per the order, as per the report of the IO.
It was
And the wife of the son has took away that money that was recovered.
Yes.
Yes, part of it was recovered, my lord.
Priyanka is one of the accused in this case.
She is the accused. Yes.
Now my question is, if 95,000 is returned to the petitioner,
My lord.
correct? 95,000 being a part of the alamat at the time of trial, how this particular alamat will be proved before the court? Because the denominations of the notes have a number, specific number.
Lordship.
So how that will be true? Yes.
Yes, that is not mentioned in the serial list, my lord. The denomination number, my lord.
Yes.
Numbers not mentioned.
Yes.
Not mentioned.
Not mentioned.
Where is the Caesar list?
My lord, serial list. May I-
লেখা আছে আমার। আচ্ছা, পরে দিয়ে দেবো যদি এরকম করে হলো কনসিডার করেছে আমি। হ্যাঁ? না, না, আমার
This is
আমার দিয়ে দেবো আচ্ছা করে এটা কনসিডার করে
আমার ব্রিফটাও চলে গেছে ম্যাডাম, ম্যাডাম আমার ব্রিফটা চলে গেছে মাঝখানে মাঝখানে। হ্যাঁ হ্যাঁ
Which one?
My lord, I have fold the page. Open the page, my lord. Open the page, my lord.
Oh.
কিন্তু প্রিন্ট করার তো পয়সা দেবে না বাবা।
Which is the order?
Impugn order is
Impugn order ends with the petition, my lord.
22nd of December
Order
2022.
dated 22nd December 2022.
Order number 10, my lord.
যেটা বলতে যাচ্ছি না মানে পুরো বলি না এখন অন করো না প্রিন্টিং এর তো প্রসেস প্রিন্টিং এর তো
What is the stage of the trial?
That is not mentioned in the case diary, my lord. Only charge sheet submitted. I have one Xerox copy of the charge sheet is filed with the case diary, my lord. No.
মনে কাউকে বোঝাচ্ছে বলবো তেরো
This lady is the complainant. Petitioner is the complainant.
Madam?
Petitioner is the complainant.
Yes, defecto. Petitioner is the defecto.
No. This shall not be returned.
My lord, this procedure has also, lordship, this procedure of return, my lord knows that has been also detailed in a judgment of the Honorable Supreme Court. May I just rely on that for a moment, my lord? It is, my lord, the case of Sundarbhai Ambalal Desai versus State of Gujarat, reported in All India Reporter 2003, Supreme Court 638. Now, if your lordship kindly comes to paragraph 11, which is at page 5 of the judgment, my lord. Yes, my lord is there. Yes, may I place it, my lord? This is with regard to valuable articles and currency notes. With regard to the valuable articles such as gold, golden or silver ornaments or articles studded with precious stones, it is submitted that it is of no use to keep such articles in police custody for years till the trial is over. In our view, this submission requires to be accepted. In such case, magistrate should pass appropriate orders as contemplated under section 451 CRPC at the earliest. For this purpose, if material on record indicates that such articles belong to the complainant at whose house the theft, robbery, dacoity has taken place, then these articles be handed over to the complainant after preparing detailed proper panchanama of such articles, taking photographs of such articles and a bond that such articles would be produced if required at the time of trial, and after taking proper security. For this purpose, the court may follow the procedure of recording such evidence as it thinks necessary, as provided under section 451 CRPC. The bond and security should be taken so as to prevent the evidence being lost, altered, or destroyed. The court should see that photographs of such articles are attested or countersigned by the complainant, accused, as well as by the person to whom the custody is handed over. Still, however, it would be the function of the court under section 451 CRPC to impose any other appropriate condition. In case where the articles are not handed over either to the complainant or to the person from whom such articles are seized to or to its claimants,
then the court may direct that such articles be kept in bank locker. Similarly, if articles are required to be kept in police custody, it would be open to the SHO after preparing proper panchanama to keep such articles in a bank locker. In any case, such articles should be produced before the magistrate within a week of the seizure. If required, court may direct that such articles be handed over to bank to the investigating officer for the investigation and identification. However, in no set of circumstances, the investigating officers should keep such articles in custody for a longer period for the purpose of investigation and identification. For currency notes, similar procedure can be followed. Now, if your lordship kindly for once comes to para 4, here section 451 and 457 were conjointly discussed and considered, my lord.
Para 4.
Para 4. My lord is there. Kindly says. Learned counsel further refer to the relevant sections of sections 451 and 457 of the Code of Criminal Procedure. So both these sections were conjointly read here, my lord, and discussed.
Commitment process is over.
Commitment, I'm not.
Commitment. It is not possible for, in case diary, there is no reflection. Last reflection CJM.
CJM. Commitment হয়নি আমারটা তো CJM
না এটা তো
আরে বাবা এ তো 12
Commitment is over.
My lord,
Commitment is done.
there is no reflection in the case diary, my lord.
No reflection. In view of the decision, if an order of the CJM is set aside, if there is no commitment, then let him approach the particular trial court. In view of the order passed by the Honorable Supreme Court.
Yes, grateful, my lord.
Yes.
That's why I'm asking you whether the commitment is done or not. Otherwise,
There is no reflection in
district judge.
না তাহলে then in that event, my lord, will my learned friend come with the instruction whether commitment has come on has been done or not? তুমি কি নিয়ে আসবে instruction তাহলে ওই particular কোর্টে আমি like
It will pass over, my lord. Maybe I call the IO, my lord. I will call the IO.
Any note here?
There is no note. Note. What's your note? 95,000. It's a note. 95,000. It's a man. 55,000 for pocket. No, report on the journey.
Get the information.
Yes. 2 p.m. my lord.
2 p.m. কিছু আছে? 2 p.m. come back at 2 p.m.
Grateful, my lord.
If it is committed, then you will get a liberty to file proper application before the trial court.
Yes. Great.
No, ওটা থাকবে না। Because yes, sir, if this case diary is produced from the office of PP or
PP office. Office of the PP.
No. I am asking you, is it produced by the IO or the
Produced by the IO, my lord.
IO? If it goes to the trial, then the CD will go to the PP's office.
Yes. In that case also, IO collected the CD from the lower court. Yes.
You get the information. Yes. Get the information, come back at 2 p.m. Yes.
Of the accused, another accused is still pending, your lord. Bail clear of under section 438 CRPC is still now pending. That means commitment should not be.
Get the information in the meantime. If you have got bail surrendered before the trial court.
Yes.
Item 21.
Yes, Lord, I am for the.
I am for the state.
Copy number 2.
May it please your lordships.
21.
21, my lord.
Hmm.
My lord, we have filed a CRAN application, my lord, for extension of the interim order. And my lord, that was not considered on the earlier occasion on Monday, last Monday, my lord, due to want of case diary. So, my lord, the case diary is perhaps present, my lord. My lord, if your lordship is inclined to take up the CRAN application first, my lord, or the CRR application itself.
What is the fact of the case?
The fact is that this petitioner, my lord, against this petitioner, one complaint was lodged under section 363 and 365 of the IPC.
Oh,
yes. And then second FIR was filed. First FIR, subsequent.
In the first, there was no allegation. Subsequently,
yes.
allegation. I asked him whether 164 has been recorded or not.
Yes, yes.
And all the questions raised by my learned friends have been covered by 164 statement. But should I may hand up the CD?
Lord, the case is different, Lord. Let it be your lordship produce the case diary. But my prayer is not quashing of the second FIR because it is not permissible in the under law. Lord, I will substantiate that by appropriate, Lord, the position of law.
Who is for the complainant? You are for the complainant?
আবার লিখে দাও আমি তো লিখ আবার লিখো সুন্দর করে দেখি
Yes.
Lord, should be taking the extension application, my lord, or the quashing application?
The matter is almost same, both can be disposed of together, lordship. It will take 5 minutes for your lordship.
I'll take some time, my lord, because there is a point of law involved.
You take time.
Yes. So, my lord, the quashing application, my lord, primarily was filed. That first FIR was lodged by the father of the victim.
After the 2 PM matter, you start this. Second.
My lord. Grateful.
Okay.
Item 22.
Din. 22 din. Order go the next circuit. Because mention করে লিস্টে এসছে কিন্তু কোনোটাই তো আসছে না যেগুলো আসছে না সার্কিট বেঞ্চ নেক্সট উইক পাবি যেটা মেনশনিং এসছে তো বললো যে রাজশেখকে কেন নিয়ে আসেনি ইন্স্যুরেন্স রাজেশ সিং এটা সব আছে সন্দীপ বাবু চলে এসছে None appears on behalf of the petition. If the matter appears before the next available circuit. Chalo. Next. Even if I see it, oh, 22 you are there? 23. Not possible. Sending it. Mr. Novankur Dinna, 23. Mr. Novankur Pal, learned advocate for the petitioner, seeks accommodation. Let the matter appear. This is a motion stage or sir? Motion stage. Let the matter appear before the next available circuit bench. No. 173 order passed, sir. This is not a more. What was the direction? Then
We have not received the copy, my lord.
Mr. Novankur Paul, learned advocate for the petitioner, seeks accommodation to, where is the affidavit of service? Seeks accommodation to file affidavit of service. Mr. Niloy Chakraborty, learned advocate, appears for the state. Petition is directed to file affidavit of service on the next day. Let the matter appear before the next available circuit bench. You file the affidavit of service on the next day. Yes, Mr. Ganguly.
I grateful acknowledge that serving upon the prejudice from this not
Complete.
My lord, in this part a CD is required, my lord.
Mr. Choro Ganguly, learned advocate for the petitioners, submits that the service upon the private opposite party is not yet complete. Mr. Niloy Chakraborty, learned advocate, appears for opposite party number 1, state. You have served, you have not received the report of the consignment track. Owner, Mr. Ganguly submission ওখানে বলুন, he seeks accommodation to file affidavit of service. Petition is directed to file affidavit of service on the next state. Next state is directed to produce the case diary on the next state. Let the matter appear before the next available circuit bench.
Yes, number.
Yes, number. Yes. Yes, number. Sheet over 444 2019.
25 days. What is it?
Retreat better
Mr. So and so, learned advocate for the petitioner. You have served the copy?
Yes.
Next circuit. Next week. Not been asking to come in the next circuit.
It is a CD দরকার আছে নাকি এটা?
Next one.
My lord, if CD is required, though they said if CD is required, my lord may.
Mr. So and so, learned advocate for the petitioner, seeks accommodation. Mr. Niloy Chakraborty, learned advocate for the state, submits that the case diary is required for the hearing of the application. State is directed to produce the case diary on the next date fixed. Let the matter appear before the next available circuit bench. No.
দাদা এটা নিয়ে জানেন।
My lord, Passover matters. Can it?
এক সেকেন্ড, একটা 25টা আছে 25টা।
20. I am for the state, your lordship. My lord, I contracted with the IO, my lord. Charge has already been framed, my lord. Case has already been committed and charge framed. নিষেধ তোমার কালিম্পং না নিষেধ তোমার মিরিক তো দার্জিলিং কাশিয়াং additional district and session judge একজন এই দিকে তো একটা
When is the date fixed for trial?
Date is not sure, my lord, but session was fixed for trial.
এই কপি জাজমেন্ট কোথায় গেল? এই জাজমেন্টটা দিল this criminal revisional application has been filed. Challenging order dated 22nd December 2022. Fast file. Learn it. Additional district judge. Not additional chief judicial magistrate. Chief judicial magistrate. Axiom. Darjeeling. In GR case number 132 of 2022. Arising out of Mirik police station case number 35 of 2022. Under section 306, 423, 380, adding sections 411 and 414 of the Indian Penal Code. Rejecting the application of the petitioner for return of seized currency notes filed under section 451 of the 457 of the 457 CRPs. এই এসিটা বন্ধ করে আজকে ৭ তো The brief fact of the case is that the petitioner, being the owner of a residential house together with land. House was sold. What was sold?
Portion of land, portion of the residential land, my lord.
Being the owner of a residential plot of land, sold a portion, sold a portion of the said plot situated at Panighata, Miri, Darjeeling, in favor of one Shama Mondol at a consideration of rupees 3 lakhs. The said property was sold out by the petitioner to pay off a loan which had fallen due. The sale proceeds of rupees 1,50,000 was stolen by the son of the petitioner, Pradeep Khawas, within brackets, since deceased. Subsequent thereto, the son of the petitioner, namely Pradeep Khawas, committed suicide by consuming poison. Consuming poison. The petitioner lodged a complaint before the officer in charge Mirit Police Station on 28th October 2022. And FIR being number 35 of 2022 was initiated. During the course of investigation, out of 1,50,000, the police authority recovered an amount of rupees 95,000 from the house of, which Pramesh Chetri is the other accused.
Yes, yes, no.
House of accused Pramesh Chetri. The petitioner filed an application under section 457 of the Code of Criminal Procedure for release of the seized amount of rupees 95,000. Stop. Upon hearing the learned Additional Chief Judicial Magistrate Siliguri, no? Siliguri. Karsiam. Siliguri, no, Karsiam. Rejected the prayer of the petitioner. Hence this revision. Hence this revision. You are Mr. Bhattacharya?
Yes, my lord.
Mr. Kunaljit, no? Kunaljit Bhattacharya, learned advocate for the petition. submits that it is not in dispute that the petitioner is entitled to receive such amount of rupees 95,000 seized, being the since she owns the seized amount. She owns the seized amount. The prayer of the petitioner was rejected only on the ground of gravity of the offense. Placing reliance on the decision of Honorable Supreme Court, he submits that the learned court should have followed the guidelines laid down by the Honorable Supreme Court in respect of seized currency notes. He prays for passing necessary order. Learned advocate, Mr. So-and-so, Kollol Acharji, no? Learned advocate for the state, does not raise any objects. Give the CD. Yes. For hearing of the application, report was the report was called for from the investigating authority. Page number. I have flagged the page. And the investigating agency submitted its no objection to release the seized currency to the holder, namely the petitioner. However, the prayer of the petitioner for release of the aforesaid amount of rupees 95,000 was rejected on the ground of gravity of the offense. In Sundar Bhai Ambala Desai Sutra, the Honorable Supreme Court observed as follows. So 11 to 13. It's 8 out of 11. 11 to 14. In view of the proposition and guidelines laid down by the Honorable Supreme Court in the decision of Sundar Bhai Ambala Desai Sutra, the order of the learned Additional Chief Judicial Magistrate, dated order number 10
22nd, my lord. 22nd of,
there are two orders. One is order number 9, and there is
yes,
10.
order number 10, my lord.
Order number 10 dated is liable to be 22nd December 2022 is liable to be set as. Accordingly, the order number 10 dated this passed in passed in GR case number such and such by status. The revisional application is allowed. So you have to take out separate application. That application cannot be considered by the court. Before the trial judge, you take out application.
My lord has granted me that liberty to take out another application there. Kindly grant me that liberty, my lord, with a direction that the trial court will consider it in light of this.
Yes, you place. You file an application. This speaks of everything. Petitioner is granted liberty to file application before the
One indulgence,
trial court.
Court below.
One indulgence, my lord. My lord, this stolen by the wife of the son. That is daughter-in-law, my lord. My lord has recorded as stolen by son.
Whatever you will write, that way you
No, my lord, kindly see paragraph 3. That the opposite party number 2 was married to the now deceased son of the petitioner, Pradeep Khawas.
Opposite party number 2. Son, opposite party number 2. She is this daughter-in-law.
She is the daughter-in-law.
Opposite party number. This stolen যেটা আছে problem. যেটা son বললাম since deceased, make it opposite party number 2, daughter-in-law.
Gratefully, my lord has granted me liberty to file appropriate application.
Trial court.
Before the trial court. Great.
এটা এর মধ্যে রাখুন।
নাম দিলাম কোনটা আমাদের না বললো হ্যাঁ
সেকেন্ড যেটা মানে 2 PM এর পরে সেকেন্ড যেটা ছিল
21 হ্যাঁ 20 পরে তো 21 হবে 26 আগে I am from the state lodge.
I'm in 26 after this maybe. One thing, in the morning your junior mentioned a matter. That's it. Stating that the case number is wrong.
Yes, my lord, I was informed.
Case number in the order I have correctly mentioned. It is of the year 14. Kindly take appropriate steps for correction in your application. It is 12. First paragraph says it is of 12, it will be 14. Other record shows that it is of the year 14. Mr. Chaudhary.
Yes, my lord.
A procedural guidelines was laid down.
Yes, my lord.
By this court in CRA 29 of 2022 for non-disclosure of identity of the victim in cases of sexual offense and POCSO.
Lordship.
From the application, apparently the name of the victim as opposite party number 2 appears. And in all the annexures, the name is appearing.
My lord,
that defect has to be removed following the guidelines laid down in CRA 29 of 20.
my lord, name has not been taken. My lord, it is written as daughter of the de facto complainant. So far I can see, my lord. Daughter of de facto complainant. And my lord, so far as the annexure is concerned, my lord, that is the document of the government, my lord, how to redact the name in that.
Your application states that Ratni Lohar, but she is the victim.
Oh,
She is the victim.
yes, yes, yes.
Huh? So
But
whatever
leave may be granted to redact the name, my lord, in the court itself.
the procedure has been laid down, that at the time where suppose it is a FIR, the name of the complainant.
Lordship.
You cannot strike that.
Hmm.
So put it in a sealed cover. Every
Lordship.
procedure has been laid down here.
Lordship, Lordship, Lordship. Justice
You can get a
Bakchi's
copy
judgment.
of this. I'm just showing it to you for your convenience.
Justice Bakchi's judgment. I am aware of it, my lord.
So I will also ask the registrar to follow these guidelines.
My lord.
Because in that judgment, it is written that till the rules of the High Court is amended, these rules has to be followed. Come to the fourth rule where the annexures are being given with the petition. It should be in sealed cover.
Lordship, Lordship. Redacted copies of the pleadings. Yes, yes, yes.
You download the copy from the
Yes, yes,
website
yes,
and
yes.
remove the defects.
29 of 29. Well, for now, leave may be granted, my lord, to redact the name from the.
I'm passing order.
Yes, yes. Lordship.
Giving you liberty to do that.
Lordship, Lordship.
Yes, Mr. Biswas.
Yes, Lordship.
This defect has to be cleared.
This has to be cleared.
This has
And
to be
followed by that matter may be taken up hearing. Because the interim order, the no coercive order, action, this order is operating as a solid rock in the way of proper investigation of the case. So our officers are facing conundrums.
Actually. This revisional application under 482 of the Criminal Procedure Code arises out of Banurhat Police Station, Banurhat Police Station, case number 104 of 2023, under sections 328/376 within bracket 2 within bracket 6 of the Indian Penal Code, read with section 3(1) Roman 12 of the SC/ST Act, SC/ST, scheduled castes and scheduled tribes within bracket Prevention of Atrocities bracket close Act 1989. Pending before the Court of Additional District and Sessions Judge. First court, Jalpaiguri.
There is a special court, Lordship.
Huh?
That is a special court under the State Prosecution of Atrocities Act.
Petitioner is directed to take appropriate steps following the practice directions laid down in Prafulla Mura versus State of West Bengal and another CRA in CRA within bracket DB bracket close 29 of 2022 dated 18th April 2022. In the petition also, you have to make necessary corrections. You follow that direction and then let the matter appear before the. How long will it take? Matter can be heard in this circuit.
Since my lord, there is an interim order which has expired and my CRAN is pending, my lord, extension application.
My lord, the interim order is getting into our way of investigation.
No, my lord, I have.
Since no question now, we need him for custodial intervention.
And my lord, or it has to be extended because I cannot be left remediless, my lord.
Kindly fix the matter tomorrow if they can do it in course of the day, lordship. Kindly fix it tomorrow.
Not tomorrow, 10th.
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 Lord, kindly extend till then, my lord, because CD is here. Till then, my lord.
10th.
7 তো আজকে।
10th রাখুন। 10th.
লর্ডশিপ
8, 9, 10 কত তারিখ? কি বার?
The interim order. It has already expired.
Yes, my lord.
In first week of August, on Friday it has expired.
Yes, yes.
Filed a CRAN also.
CRAN is pending.
CRAN is there, lordship.
Huh?
CRAN application they have already filed.
CRAN is there.
Yes, yes.
Then the interim order granted earlier on.
কি হবে তোমার? তোমার দিঘা হবে।
12 June 2023. এই গ্র্যান্টটা কোথায়? Grant 2 of 2020, Mr. Chaudhary? 2
Yes, my lord, 2.
earlier be extended till 11th.
My lord, my lord.
I'm disposing of the CRAN
Lordship.
till 11th. Let's see how it goes.
Lord, if it taken upon 10th, my lord, I have no difficulty in it. Let him know.
I don't know. I have given you a date. How
Yes.
the court proceedings goes, I don't know.
If it is fixed on 10th, I have no difficulty. I am ready with my CD and
The only thing is these things has to be clarified. No? This defect
Lord,
has to be new. Otherwise, this
Only only one difficulty, my lord. If it does, if matter does not reaches on 10th, my lord, so
11th image.
then
I've
we'll,
given you till 11th. On 10th, if it doesn't come, you mention because 11th
Great,
will be
great.
less matters. So if I cannot complete that within 11th, I will extend it.
grateful, grateful, my lord.
This is what I've thought of. There are
Grateful.
other matters too.
Yes,
which
yes,
has
yes.
been going on hearing.
Yes, yes, yes.
If I cannot complete that, I will extend that.
Lordship.
As of now, CRAN is disposed of. You just mention. And that
Grateful.
the extended orders will be within the time. So I can extend that order without the application.
My lord, my lord. Grateful to your lordship.
CRAN to dispose of.
নাম দিয়েছিস? নাম
একটু না একটু রেজিস্ট্রার সাহেবকে একটু ডেকে দিন। রেজিস্ট্রার সাহেবকে একটু ডেকে দিন। বলেছেন তো?
ওটা এখান থেকে ওটা রিকমেন্ডেশন গেছে কিনা আমি আপডেট পাবো সারা
ঠিক আছে। What is the order? Mr. So and so learned advocate for the petitioner Submits for fixing the matter before the next available circuit. Let the matter appear before the next available circuit. Yes.
Item 27.
Wow.
Correction का people ने अपने नाम में 18 department.
Not only corrections, sir, there are other also procedures which you have to do. You go to the department, go through. I have asked Mr. Chaudhary to go through the guidelines, and thereafter you do it.
May I, my lord?
Yes.
My lord, I am here with regard to application under 407 of CRPC with regard to transfer of cases, with regard to transfer of a case. My lord, if we come to the backdrop of this case, this case is initiated. This case, there are two cases. Firstly, the case of TS 282 of 2021 pending and before the learned civil judge junior division Bidhan Nagar in the Calcutta side. This is in the appellate side, Bidhan Nagar, and in counter to which a CR case number 452 of 2022 third court judicial magistrate third court Kuch Bihar is pending. This both case happens to be the counter blast of each other. Now, this happens to be the counter blast of each other of case. First, the civil dispute was initiated, and in return of which a criminal case was filed before the Kuch Bihar.
So your prayer is for sending the.
Yes, my lord. On account that the petitioner is ill, he suffers for and he stays alone.
He or she?
She. And there is a distance of more than 1,000 kilometers, 1,300 kilometers.
So, who is this? What is the dispute?
My lord, this dispute happens to be on joint purchasing of a land and then leasing out. So, and in accordance to that, there were several exchange of checks and blank checks. And with regard to this civil dispute, a criminal color was given in the Kuch Bihar court.
No, civil dispute is with regard to 130 and negotiable investment.
No, my lord.
A criminal case?
A complaint case was registered eventually.
138?
Yes, my lord.
Ashwin, this revisional application has been filed under 407 of the Criminal Procedure Code for transfer of CR case number 452 of 2022. Pending before learned judicial magistrate, third court, Kuch Bihar, to the court of learned additional chief judicial magistrate, Bidhan Nagar, 24 Parganas North. Upon hearing the learned advocate for the petitioner, it is found that the presence of the opposite party is necessary. Petitioner is directed to serve copy of this application upon the opposite party, I registered through registered speed
Naam di
post with
Mr.
acknowledgement deed
Naam
and
di
file
Mr.
affidavit of service on the returnable day. If the matter
My lord, one indulgence, a stay may be given.
Absolute Steve. Sir, serve the copy.
My lord.
Next.
Item 28.
28, I am for the petitioner, lordship. Am I audible?
Yes.
Lordship, the petitioner before your lordship is filed this application for quashing of the CR case number 227 of 2022, filed under section 138 of the Negotiable Instrument Act, pending before the Learned Judicial Magistrate, Second Court at Alipur.
Alipur Duar.
Alipur Duar, lordship.
Sorry, Alipur.
Alipur Duar. The main contentions of this revisional application is that, lordship, at the time of taking cognizance by the learned magistrate, the section 202 of the Code of Criminal Procedure was not followed, as the address of the petitioner, that is the accused person, is beyond the jurisdiction of that learned court. The jurisdiction is of Jalpaiguri, and this filed in the court of Alipurduar. Moreover, in the complaint application, lordship, in the complaint application, which is annexed as page 18 onwards, the petitioner never stated that whether the said check was issued by the accused person to the complainant in tune of the payment made by the complainant to the petitioner. There was no such indication.
Sir, copy to the other side.
Only paying for a short limited period of stay, lordship, as the next date is fixed for plea. And
Taken. Of the copy. This is an application under section 482 of the Criminal Procedure Code. Praying for quashing of CR case number 227 of 2022, filed under section 138 of the Negotiable Instruments Act, pending before Learned Judicial Magistrate, Second Court at Alipurduar. এবার ঠান্ডা লাগিয়ে দিয়েছি এসিটার জন্য। আপনার কিন্তু থামাবে না, চলতে থাকবে, না বললেও আপনার কথাতে চালিয়ে হালকা করে রাখবে। কি বললাম? Pending before Alipur. Mr. Partho Sharathi Das, learned advocate for the petitioner. The brief fact of the case is that the opposite party filed a complaint case under section 138 of the Negotiable Instruments Act. 138. And considering the materials on record, the learned magistrate issued process against the petition. Challenging such proceedings, the petitioner has filed this revisional application for quashing of such proceedings. Now, Mr. Parthu Sarothi Das, learned advocate for the petitioner, submits that the processes has been issued by the learned magistrate without complying the mandatory provisions of section 202 of the CRPC, since the petitioner, within bracket accused person, resides outside the jurisdiction of the learned magistrate at Alipurduar. Resides at Jalpaiguri, which is outside the jurisdiction of learned magistrate at Alipurduar. Upon hearing the learned advocate, it is found that the applications needs to be heard in presence of the opposite court. Petitioner is directed to serve copy of this application upon the opposite party through registered speed post with acknowledgement due, and file affidavit of service on the returnable date. Let the matter appear before the next available circuit bench.
Lordship, praying for a limited period of stay, Lordship. Is as the next date for is fixed for plea, Lordship.
Serve copy and come back.
Lordship, that may be given, Lordship. After completion of service, I can pray for stay, Lordship.
Will appear before the next available circuit bench. In the meantime, you serve the copy and come back.
Lordship, grateful, Lordship. Grateful.
Item 29.
Item number 29, I am on behalf of the petitioner, my lord. This is a domestic violence case. The petitioner herein is the husband, and the wife had filed this domestic violence case wherein monetary relief was granted to her by the judicial magistrate of an amount of rupees 5,000, against which she has gone for an appeal, and that amount was enhanced to rupees 8,000. Against that order, I filed this criminal revision. Now, my lord, both the lower courts have not complied with the direction of the Honorable Supreme Court in the case of Rajneesh versus Neha, where there has been a direction to give asset declaration by both the parties. That has not been complied. The order is in page number 12, the Judicial Magistrates Court order.
Page 12.
Page 12. It's an online copy of the order.
You also did not give the asset declaration.
I also did not give, the wife also did not give, but I have given the income tax return copy, my lord, where it is clearly shown that I have a monthly income of rupees only 10,000, my lord.
You did not disclose your assets. Now you raise this plea.
My lord, it is supposed to be disclosed, my lord. It is a direction.
The learned district judge or the court below that asset declarations require. I am placing my asset declaration. Let her also place the asset declaration.
Done by the lower court's lawyer, my lord. It is not my fault, my lord.
So you are raising this issue.
Yes, my lord. That is a valid.
You have also placed your asset declaration or not?
My lord,
you should have complied before.
Yes, my lord. Yes, my lord. Then, my lord, the thing is that the petitioner hearing the husband, he has only an income of rupees 10,000 per month, my lord. Whereas the amount of monetary relief which has been granted is rupees 5,000, my lord. And thereafter it has been enhanced to 8,000, my lord. The petitioner hearing is an advocate, my lord. And the wife is MA in political science, my lord. Those things have not been considered.
Where is the order of the trial court?
My lord, page number 12, my lord. Both the parties have been.
What is the order passed by the district judge at the time of admission of the revisional application?
That order is at the end, my lord. The certified copy has been annexed.
What was the initial order passed by the sessions judge at the time of admitting the appeal? Was there any order passed by the court directing the petitioner to go on making payment
Payment of
rupees
rupees 5,000.
What is that?
That order I have not annexed, my lord.
Order not annexed.
No, my lord. I have not.
You have complied that order. Was there any direction?
My lord, there was a direction.
Where is that?
There of 5,000 rupees to be when the wife has filed.
Where is that?
The wife has filed the appeal, my lord.
Wife has filed the appeal.
Yes, my lord. Not the husband, my lord.
Then the interim order that was passed, you have complied that order.
No, my lord.
You have also not complied.
That is an execution case is going on over there. He's making a few payments, my lord. The wife has filed the appeal. The husband did not file, my lord.
You have not complied that order. Trial court's order.
My lord, I have to take instruction, my lord. What payment he has made till to date, my lord.
Otherwise, direction will pass for clearing all the dues.
My lord, he is just a budding lawyer, my lord. 5,000.
He will not make payment.
My lord, he will make payment. My lord, he has made few payments also, I think so.
Just clarify whether you have complied the order of the court or not. If you are an opposite party in the revisional application before the sessions judge,
yes, my lord.
Then the order passed by the trial court
Yes,
was to make deposit by 10th of each month.
Yes, my lord.
Till you file an application, you need to pay for a stay of that order. So have you made payment of 5,000 that was directed by the trial court?
My lord, I think he has made few payments in the execution proceedings which has been initiated by the wife.
Till filing of the execution case, did you out of your own volition make any payment to the
That I do not have any instruction in that.
So that is required.
Yes, my
of
lord.
which month you have made payment?
Yes, my lord.
Huh?
I'll ask him and I'll.
And you have not disclosed your assets also.
No, my
Court
lord.
says that neither parties have produced any documents.
Yes, my lord.
She claimed that your income is 1 lakh.
Yes, my lord.
Huh?
Yes, my lord.
But no documents were placed.
No, my lord.
The considered prima facie case, the court has granted 5,000.
My lord, I have annexed my income tax return which clearly shows 10,000 rupees is my monthly income, my lord. That's in page number 33. 33, 34.
33. ये थे कब আছে কাল বা 9 ইমোশন শুনে নাও 9 বা 10 এ ভাই 10 ম্যাক্সিমাম 10 8 এটা 9 নম্বর আইটেম রেখে দিন 10 10 জন রাখো যদি হয় come back on 10
with instruction, my lord. I'll ask him, my lord. Yes, my lord.
Miss, your name?
Rima Sarkar.
Rima Sarkar, learned advocate for the petitioner, seeks accommodation to take appropriate instructions from her client. Let the matter appear on 10th August 2023 under the same heading.
Grateful, madam.
Hey, Passover, where is Mr. Chakraborty? CD has been produced. That you have not taken in. You have not taken information whether CD has been produced or not. Till now not produced means let the matter appear before the next step. He is not there, Mr. Chakraborty.
One.
For order to park the city.
Order?
My lord, in this matter, may I appear on behalf of the petitioner, my lord? My lord, in this matter, I am appearing on behalf of the petitioner, my lord. The matter was, as per the last order passed by this honorable court, the matter was scheduled to be appear on 3rd of August, my lord. But the matter did not appear on 3rd. We mentioned the matter before my lord, and my lord desired that the matter to be appear on 9th. And also my lord, CD was called for, not by my lord, but in the circuit bench before this circuit. Now, my lord, today the matter appears in the list. The matter was called, and the learned state government advocate, he took time to place the CD. But, and since then, my lord, no CD has come forward.
Matter was supposed to appear on 9th.
Yes, my lord, the matter was, when we mentioned, the matter was supposed to appear on 9th, as my lord desired. My lord verbally expressed so.
You know that 9th it is possible. He says your junior, the learned advocate appearing on behalf of the petitioner before me, he says that the case diary has not been produced as yet.
Yes, my lord. The case diary is being called for by this honorable court again and again, and case diary is not being produced, my lord. And my lord, this application is pending for long. And it is not the case, my lord, that the state government is not aware, the state is not aware that case diary has been called for. Case diary was called for in his presence, my lord, in the presence of the state government advocate, my lord.
next circuit with a specific.
My lord, kindly, my lord, take it on 9th. And if my lord places this next circuit, kindly then place all the proceedings in the lower court in abeyance. My lord, because this is, we cannot, my lord, suffer for an indefinite period due to their laches, my lord. They are trying to evade the honorable court. They are not appearing. They are appearing then without any case diary. There was clear instruction upon them that case diary was being called for. My lord, kindly see the last order passed by this honorable court. Clearly mentioned, my lord. Last order passed by this honorable court, my lord, as back as on 11th July 2023. Case diary.
What is your name? Pushpashish.
My lord, I am Mr. Piyush Bishas appearing with Mr. Pushpashish Gupta.
Mr. Piyush Bishas, learned advocate for the petitioner, submits that in spite of repeated direction of this court, the case diary has not been produced for hearing of the matter. Although learned advocate for the state was present on the in the morning when the matter was called, stop, no, comma, however, he is not present before the court. Stop. When the matter is taken up in the second half. By order dated 11 July 2023, direction was given to the state. You are for the state. State to produce the case diary. However, no information has been received from the state regarding production of the case diary. For such reason, the matter stands adjourned. State is directed to produce the case diary positively on the next date fixed. Let this matter appear before the next available circuit bench.
My lord, till then limited protection, my lord. We are before my lord on repeated occasion. Till then limited protection.
चलो नहीं एक लोग डिस्ट्रिक्ट को छोड़ देना दूसरे के साथ से सुनते हैं ऑर्डर पास करते हैं ठीक है सर थैंक यू सर
My lord, till then limited protection. I beseech to my lord. They are evading, my lord. We are suffering.
Next week there will be next circuit. You mentioned it for listing and also calling for. I've given specific direction to the state to produce the case diary.
My lord, one small indulgence. Instead of just saying before the next circuit, my lord, kindly indicate a date. Subject to the convenience of the next bench, obviously. Kindly indicate a date.
Date 16th August. 16th.
Grateful, my lord. Grateful, my lord.
ক্যাপস লকটা কোথা থেকে ওই তো তুমি ক্যাপস লক করলে তো আবার আবার করবে ক্যাপস লক বন্ধ করো
I can practice.
কি বলছেন বলুন না তখন রেজিস্টার সরোজবাবুকে তখন আমি একটু ডিকটেশন দিয়ে সরকার মানে আমি কি করবো এখানে আমাকে একটা ইয়ে দিন আমাকে একটা মেশিন দিন আমি তাহলে করি I have to give them relief না সে একটু বলছে বারবার লোক নেই কি অবস্থা ডাকুন রেজিস্টার বলি রেজিস্টারকে ডাকুন আমার আপনি চিন্তা করবেন আমি থাকবো হাতে ফিকে দেবো মেশিনে থাকলে ড্রাগনে কিছু করে তো এই সমর্পিতাকে দিয়ে দিই লিখটা সমর্পিতাকে দিয়ে দিই কিছু ঠিক ওকে গিয়ে আবার ওখানে বলতে হবে। চলো বলুন।
Lordship.
Yes.
Lordship, item number 30 and 31, Lordship.
Huh.
So item number 30 has been filed by this appellant, Lordship.
30 and 31.
30 and 30. Court has been filed from the side of the insurance company, Lordship.
Oh.
And this appeal has been filed challenging the order, dismissal order of the learned tribunal, Lordship.
Where is section 5?
It speaks from hearing, Lordship.
Yes. File a section 5 application in cross objection. 6 days delay. Produce the report of Deputy Registrar dated 31st August 2019. It is found from the aforesaid report that the cross objection has been filed, is delayed by, cross objection is delayed by 6 days. Cross appellant insurance company is directed to take appropriate steps. Let the matter appear before the next available circuit.
I am appealing for the appellant, Your Lordship. This is my appeal, Your Lordship. I filed
But one small indulgence, Lordship. Actually, the last order, Honorable Justice BIVAS from the Lordship, in the last circuit, passed a direction upon the public prosecutor to produce the case diary for the adjudication of this last matter, 30 and 31, Lordship.
Let him first file his section 5 application with regard to cross, then mention before the available circuit. Let him file an application first.
The CD is lying in the fully CD actually lying in the CD. Money it will be returned or it will be served.
I don't know. I cannot say anything.
But there's a direction, Lordship, to call for the CD. CD has been produced, Lordship.
Let it be there.
Return
Next.
back, Lordship.
Huh?
It will be returned back otherwise, Lordship. If there is no direction to hold the CD.
Didn't you? Or didn't? But nobody is submitting that the CD has been returned.
No, Lordship, as per the direction of your Lordship, CD was called for, Lordship.
CD was called for. Have the CD been?
has been produced by the Lordship.
Who is there? Who is he?
From the PP office.
So any person from the PP office will produce this before the honorable court? Or will there be an advocate to produce the case diary before the court?
Direction was upon the PP, Lordship.
So where is the any representative of the PP? I cannot take him. He is a
lawyer to take an
office bearer of our office will come and place the case diary before the
lawyer
court.
should be present, Lordship. He has come with the CD.
Fast food. Sure. Let them come. Huh? Date যা আছে আছে ওটা রিটার্ন করে দেবো আগে। Mr. Chakraborty, CD has been produced in this case.
No, it's not 30. There's the direction.
দেখি দেখি ফাইলটা দিই।
Direction ছিল PP office সিডিটা পুলিশ পাবে
CD has been produced. When the direction was passed?
Well,
or for case diary through learned. The related case diary has been produced On 7/7/23. Chakraborty, kindly hand over the case diary.
7/7/23. The 7/7. 7/7.
কি বলো? By Mr. Niloy Chakraborty, learned advocate for the state. Since there is delay in the cross objection, due to which the matter has been adjourned, the case diary produced in relation to Mathabhanga PS case number 388 of 2014, dated 4/9/2014, be 4/9/2014, be returned.
Grateful, Lordship.
At this stage, returned at this stage. Or written at for a language. Yes, 30.
I'm for the appellant, Your Lordship. People who got it. So, short points involved in this appeal, Your Lordship. The deceased was a businessman. He died due to the accident. Now the income tax official came from the office and proved the income. Now, since he was a businessman, Your Lordship, the future prospect ought to have been granted. The future prospect was not granted.
What was his age?
Age, Your Lordship, 48 years. So future prospect would be 25%, Your Lordship.
48 years.
48 years.
Self-employed.
Self-employed business, Your Lordship.
25% future prospect not considered.
Future prospect was not considered. So 25% future prospect would be considered.
Next.
Now, second point, Your Lordship, the general damage. So general damage was granted 9,500.
166, 70.
166.
72.
So that should be 70,000.
Yes.
And Your Lordship, third point, Your Lordship, the income.
Income.
He was a businessman. 3 years income tax profit return was filed in the court. My submission, Your Lordship, the latest income ought to have been considered. But the learned judge, Lordship.
Assessment year.
Your Lordship, year 3 years were filed. Your Lordship, can you come to the evidence of PW3? Page 19. Page 19. This is Deepak, right? You also got it. 19. Deepak Rai, PW3. May I place it, Your Lordship? My name is Deepak Rai, assistant at IT assistant at Jalpaiguri, being duly authorized by IT office, Jalpaiguri, ward number such and such. This is the letter of authorization This is the certified copy of the income tax return filed by the SSC, Mahendra Kumar Chajia, for assessment year 2014-15,
when did the
2015-16.
accident take place?
Accident, Your Lordship, 2017, 19-117. 3 tax returns were filed before the accident.
These are prior to accident.
Prior to accident. Both,
Which is the proximate to the accident? Which is?
Your Lordship?
Which assessment year is proximate to the accident?
Accident.
Just prior to the accident.
Prior to the accident.
Which one?
Even Your Lordship, that was admitted in the cross-examination. At present, I am posted at Jalpaiguri. My date of appointment is 1/5/2014. This is the original ID card issued by the Government of India. The ID card is compared with the original and the Xerox marked as Exhibit A. I have got the code, the original documents of Mahendra Kumar Chajia as well as the certified copy. Income tax return for the assessment year 2014 was submitted on 24th March 2015, well before. And the return duly signed by the SSC. Specific income from the business is not shown in the duly, shown in the as code. The code is shown as 0204. The net income of the assessment year 2014 is 2,40,10. Net income for the assessment year 2015 is 2,81,870, and the net income is 2016-17 is 2,81,420. So this is after deduction of from the gross income. Now my submission, Your Lordship, the last income, which is 2,89,480, this ought to have been taken. But what the learned tribunals did, that learned tribunal stated that I have taken the average of 3 years. Now, but you see, there's even in the wrong in that. If the 3 years average is taken, then Your Lordship would come to 22,549 per month. Because the yearly average income of 3 net income, Your Lordship, 2,70,586. But in London Tribunal take it 21,000. But the average is actual average of 3 years is 22,549. So my submission, Your Lordship, even if the average income is taken, then the average income is would be 2,70,560, 3 years average. And my submission, Your Lordship, that the not the average, the last submission, last year assessment year, because that was the last income. And other, Your Lordship, the 2 points, Your Lordship, the general damage and the future positive. These are my submission, Your Lordship. And I intend as well as usual, Your Lordship.
My Lordship, I have a strong objection in the point of income.
You have received the amount?
Your Lordship, yes, Lordship.
Along with interest, 6% interest, we have paid all. My Lordship, this is an income tax return, not assessed. My Lordship, that is the earned by the lower courts, my Lordship. It's merely a filing, it's a copy, nothing else. It is not assessed by the income tax assessing. And there is a different case law, this is a settled law that mere copy is a secondary evidence. How can it will be assessed in as an income?
Secondary evidence.
Secondary evidence, my Lordship. There is a Allahabad High Court 1955, 1958. There is a many case laws are there. What is primary documents and what is secondary documents? It's a secondary document. It is merely a file the only a income tax return. So income we have already paid 21,000 is sufficient. I think it is my plea.
Any other submission?
And future damage at that time it is relevant.
Okay.
And
any minors?
No, Your Lordship.
Who are the claimants?
Claimants, Your Lordship, are wife, mother, daughter, and 2 sons, but the 2 sons were excluded by the London Tribunal. Only given to wife, mother, and the unmarried daughter. So 1/3 was deducted.
Appellant numbers?
Lordship.
In favor of whom? Oh, three are the appellants.
Three are the appellants. Three are the appellants.
My lord, I am
This
just
appeal is preferred.
secondary evidence is not here.
This. This. This appeal is preferred against the judgment and award dated 6 February 2019, passed by learned Additional District Judge, cum Judge, Motor Accident Claims Tribunal. Mall Bajar. What is this designation? Mal Bajar.
Your Lordship.
Only Mal. MAL. Where is the order of the court?
Order of the court is to
Mal Jalpaiguri. MAL. আছে না? মাল জলপাইগুড়ি বলছি। In MAC case number 66 of 2017 under section 166 of the Motor Vehicles Act 1988. Now granting compensation of rupees of rupees 2193,500 together with interest under section 160. The brief fact of the case is that on 19 January 2017 at about 8 AM, while the victim was going towards Siliguri from Mathabhanga in a vehicle bearing registration number WB 74AF/8043 as occupant. At that time, the offending vehicle bearing registration number WB 71A/7536 within bracket truck in a rash and negligent manner dashed the vehicle in which the victim was traveling. As a result of which the victim sustained severe injuries and was shifted to Jalpaiguri Sodor Hospital, where the attending doctor declared him dead. In favor of claimants, all claimants today. Favor of why in favor of claimant numbers 1, 3 and 5. On account of sudden demise of the victim, the claimants being the widow, sons and daughter, and mother filed application for compensation of rupees 37,50,000 under section 166 of the Motor Vehicles Act 1980. The claimants, in order to establish their case, examined 3 witnesses and produced documents which have been marked as exhibits 1 to 15 respectively. Respondent number 1, insurance company, did not adduce any evidence. Since the owner did not contest the claim application, service of notice of appeal respondent number 2. Respondent 2. When service of notice of appeal upon the said respondent stands dispensed with. Upon considering the materials on record and the evidence adduced on behalf of the claimants, the learned tribunal granted compensation of rupees 2193 in favor of claimant number 1, 1, 3, and 5. Para being aggrieved by and dissatisfied with the impugning judgment and award of the learned tribunal, the claimants have preferred the present appeal. Mr. Shubir Banerjee, learned advocate for appellant's claimants, submits that the learned tribunal erred in determining the income of the victim by taking average of the income disclosed in 3 income tax returns, and more so, there is arithmetical error while calculating such average. So he submits that the income disclosed in the last income tax return of the victim filed just prior to the death should be considered for computing just compensation. Furthermore, he submits that the claimants are also entitled to future prospect, entitled to an amount equivalent to 25% of the annual income of the deceased towards future prospect, and general damages of rupees 70,000. In light of his aforesaid submissions, he prays for enhancement of the compensation amount. Mr. Chuanchu, learned advocate for respondent number 1 insurance company, submits that the income tax returns submitted are not the assessed income of the victim. Stop. Further, the copies of the income tax return are secondary evidence which the what is the proposition here? What is the proposition?
Proposition. Case law.
Yes.
2000 Supreme Court AIR. Actually, Xerox copy my lordship. 2000 Supreme Court 1759. In the upper side.
No, what is the proposition?
The proposition is for the secondary evidence, my lordship. That means secondary evidence application for must given full details and must be supported by the proper affidavit.
What details?
My lordship.
What details?
Details there. In secondary evidence, as per section, my plea is that the certified copy of the documents are the only the primary documents, and the secondary evidence must be proved by the before the learned court and must be by an affidavit, way of affidavit.
Secondary evidence which cannot be accepted without seeking permission under section 65 of the Evidence Act. supported by a proper affidavit and giving full details necessary to attract the provisions of Section 65 of the Evidence Act. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in State of Rajasthan versus Khemraj, reported in AIR. This is AIR?
AIR.
AIR 2000, Supreme Court 1759. Having heard the learned advocates for respective parties, following issues have fallen for consideration. Submission is in light of his aforesaid submission, he prays for dismissal of the appeal. Whether the learned tribunal erred in determining the income of the victim. Secondly, whether the claimants are entitled to future prospect at the rate of 25% of the annual income of the deceased. And lastly, whether the claimants are entitled to general damages of rupees 70,000. With regard to the income of the deceased. Now, in regard to the first issue, it is found that the learned tribunal has taken the average income of the victim disclosed in the 3 assessment years, namely 2014-15, 2015-16, and 2016-17. Exhibit, within bracket, exhibit 15 collective. Challenge has been thrown to the acceptability of the copy of the income tax return produced by TW3 IT assistant Jalpaiguri. Relying on Khemraj Sutra. The decision of the Honorable Supreme Court is not passed in respect of any claim appeals. The strict principles of Evidence Act does not apply in case of in claim cases. Such being the position, The argument advanced on behalf of the respondent number 1 insurance company falls short of merit. The income tax returns for assessment year, what are the other one? 14, 15, 15, 16, produced by the claimants has not been challenged so far. The income disclosed therein no other evidence has been produced from the side of respondent number 1 insurance company to primarily establish that the income disclosed in the income tax returns of the victim is not proper. Now it is to be seen whether the income tax returns can form basis for determination of income of the victim. Determination of income of the victim. ওখানে লিখে রাখুন মালা রিজভি কল্পনা রাজ I will give you a reference of a book করে দেবো Shamim will put it. From the aforesaid observation of Honorable Supreme Court, it goes without saying that income tax return of the victim should be taken into account for determination of income. The claimants have produced income tax return for 3 assessment years. The last assessment year of 2016-17, where is the document? 16-17? Page.
Exhibit 56 is the first document 2014-15. It's a touch it.
এতক্ষণে বলছেন receive 3 copies of NCR.
I got 1 year certified copy, so I annexed 1 year certified copy. The other 2, your lordship, are the LCR in the LCR, your lordship.
No, of 16-17 you have filed.
Your lordship,
16-17, the last one.
Yes, your lordship.
Where is that?
Lordship, that is not in the part of my paperwork, your lordship. I annexed only 1 year, your lordship, that was given the certified copy which I got, your lordship. 2014-15, your lordship,
14-15 is not required.
Not required, your lordship. The 16-17, your lordship, that is not the part of the paperwork, your lordship, because I have not got the certified copy of that, your lordship.
It was exhibited.
Yes, your lordship. Exhibit 15 collectively, your lordship.
So now they will go.
Your lordship, kindly see page 19, chief, last line.
My department document.
This is the certified copy of the income tax return.
No, instant.
For the assessment year 14-15, 15-16 and 16-17, which is marked exhibit 15 collectively. Even the London Judge, Your Lordship, at page 24 of the judgment, considered that, Your Lordship, the 3 words were filed. Page 24, top, Your Lordship.
Read the document from LCR near department logo passed over for something.
Your Lordship.
Like to pass over.
Your Lordship, there is a reflection in the judgment copy, Your Lordship. Where the
No, I want to see what is the net income that has been calculated and the income tax paid in that particular, that will be deducted from the income. এটা করে দিন তো item number 56 টাকা
Item number 56.
My lord, I'm appearing for the petitioner, my lord. My lord, this petition happens to be, my lord, that fateful event the person got stroke. I'm only applying for extension of injunction.
Injunction or stay? What is injunction?
Yes, my lord. Didi.
If you want the state earlier, is praying for extension of the same. Suppose but no why. Considering the situation, I do not object to his
that by
any place for hearing.
Stay. It's not injunction, stay order.
Stay.
When was the stay order passed?
My lord, the last stay order.
Previous 13/7. For a period of 3 weeks. Awesome. You are for opposite party?
Opposite number 1. I am opposite party number 2.
All the parties have appeared?
Yes. Yes, my lord.
1, 2. Any application file?
Yes. Can 1 of 2023. Can 1 of 2023.
Can the second.
Copy has not been served.
কাকে দেবো আমি এবির তো দেখে নিয়েছে তো স্টে পাস করেছে তো Did you file any can application for extension?
Yes, my lord. Can 1 of 2023.
Filing slip to the who is the caveator?
I am the caveator.
Oh, wait. Caveator caveat এসে গেছে
My lord.
Wait for some time.
My lord.
Let the can come and dispose of it. Next.
I don't have it check.
This is my application.
Respond number 2 is the undeliverable. Respond number 2 is the owner.
Your Lordship.
Respond number 2, owner.
Owner, Your Lordship.
3 is the driver. 1 is the insurance company. Has been issued.
This was allowed ex parte against the owner, Your Lordship. Owner did not contest. Your Lordship, the injured is the appellant before Your Lordship.
আগেরটা এনসিআর এসছে আগেরটা এনসিআর এসছে Where is the LCR? So you have received the LCR, you have to tag the LCR, that has to be, order has to be passed for tagging the LCR. পাঠ করে কেন ওখানে পড়ে আছে একটা কপি পড়ে আছে অর্ডার বুক ইমিডিয়েটলি গেট দি এলসিআর এক্ষুনি পাঠান এই হাফ ডাউন করে আমি কি করব এটা দেবো এটা হাফ ডাউন হবে দেন উইল ব্রিং দি এলসিআর অফ দ্যাট দেন আই উইল ডিক্টেট messed up with the thing sir but where is the LCR? You are sending the records without the LCR. In the midst of the dictation, I could not find the LCR. Item number bolun na lage.
Item number 30.
In all the cases, LCRs are called for.
No, in all the cases, LCR are not required. But in some cases, the LCR are being called for. They are received by the department, but that is not their LCR. পেয়েছেন পেয়েছেন that is half done dictation again this will start and again the LCR will come
Here, Your Lordship, each and every document has been annexed in the paperwork, Your Lordship, every doc exhibits.
What are the grounds?
Our grounds, Your Lordship, the injured.
Who is for the insurance company?
I am.
Mr. Chakravarti. Now, the 40% that up to have been granted, future prospect, that was not granted. He was a motor mechanic. He lost his hand. Hand was amputated. Secondly, Your Lordship, the multiplier, the London Tribunal assessed the multiplier as regards Your Lordship 163A. But Your Lordship, as per Stella Burma, the multiplier would be 18 instead of 17.
37.
And
Wait.
third, Your Lordship, that should be considered by Your Lordship that a motor mechanic, Your Lordship, he lost his hand. So it is not possible for him to continue as a motor mechanic in future. The London Tribunal considered the disability certificate. The disability certificate, as per the law, Your Lordship, that is 80%.
40% applied for calculation.
Your Lordship,
40% applied.
nothing, no future prospect, nothing, Your Lordship.
No, what is how did the calculation being made? Disability of 40% has been taken.
Disability of 40%, Your Lordship, the London judge assessed the income as 6,000. That income has been assessed by the London judge. That is 6,000.
Correct.
So 40%, Your Lordship, of that 6,000. And my ground, Your Lordship, since Your Lordship disability, according to Workman Compensation Act, Your Lordship, that is 80%. There is no doubt, Your Lordship. But the occupational loss, Your Lordship, that is to be 100%. Because as a motor mechanic, he can't act or continue his profession as motor mechanic. Since he has lost his hand, the right hand has been amputated. So instead of 80%, Your Lordship, the disability should be taken as 100%. That is my another point. And Your Lordship, the pain and suffering that up to have been granted, Your Lordship, in this type of case, Your Lordship. The boy is 22 years, Your Lordship.
Oh, suffering. This was not allowed. Pain and suffering not allowed.
Yes, allowed.
Allowed.
2 lakhs.
2 lakhs. Then again you are making submission.
Your Lordship, 2 lakhs, Your Lordship.
100%.
Pain and suffering, Your Lordship. 2 lakh.
2 lakhs granted.
Or 2 lakh granted, Your Lordship. The future medical expenses, Your Lordship. The future medical expenses, that was not granted. The medical expenditure of 10,000 was granted, but the future medical expenses were not granted, Your Lordship.
Medical expenses.
But future medical expenses, that kindly considered that, Your Lordship. And Your Lordship, the income, Your Lordship, I am not disputing that, Your Lordship, since it is assessed as 6,000, Your Lordship, that should
My Lordship.
40% future prospect and multiplier should be 18, Your Lordship.
Future prospect 40%. What was his age?
22 years. 22 years.
It is arguable. 20%. 22 years, 40%.
40%, Your Lordship.
Yes.
It is in the accident took place on 3/6/15. At that time, it is 6,000 notional income, my lord.
You will argue in support of the judgment passed by the tribunal.
Yes. Yeah, my lordship.
You will argue in support of the judgment passed by the tribunal because we have not filed any cross appeal.
No. I am not arguing on that point. My point is this: 2 lakhs already paid, pain and suffering. It is in the case of 2015, 6,000 has been already given as a notional income, highest level at that time. 80% calculated on that basis. It is right. Then what are the 80% total 100%, out of which 80% disablement, 80% calculated on the basis of 6,000. It is already paid.
80,000 disablement.
80%. Total 72,000, out of which 80% disablement, 80% calculated. Rightly calculated by the.
Oh. Where is the disablement certificate?
Your Lordship, that is exhibit 12, page. Page 46, 47. Part 2 of the paper book, Your Lordship.
46 page. 46.
Your Lordship, page 21 of part 2. Page 46, actually. 46, Your Lordship, or page 21 of the part 2, Your Lordship. Lifetime, Your Lordship. Disability assessed.
Multiplier is correct.
Multiplied 18. That should be. London Tribunal.
As per Solar.
As per Solar, multiply would be 18.
18.
And in case of medical expenses, total medical expenses 20,000. They have not proved any bill. Though also they have the learned tribunal granted 10,000.
10,000.
Not proved any bill.
আমার বলতে হবে তো শুনি না বলছে শুনি না কি কালকে করবো এটা নিয়ে কোনো হেডেক নেই আমি প্রত্যেক 15 মিনিট আমি ডিকটেশন দেবো এসছে উপকার দিন tomorrow pass order in this
Your Lordship.
You take up the previous matter. See. So the Shiro. You'll see together. আমাকে তো বলে দিন লাস্ট and from the basis determination of income, right? Yeah.
Exhibit 15, Your Lordship.
Was submitted on 16-17 বললাম তো was submitted on 27 July 2016. The accident has taken place on
19 January 2017.
19 January 2017. Thus, the income tax return for assessment year 16-17 being proximate and just prior to the accident, I am inclined to consider the income disclosed in the state income tax return. It is found from the income tax return for assessment year 16-17 that the total income of the victim is rupees 289,480. And the tax payable is tax paid. Total tax paid is rupees 2006. Thus, the actual income comes to rupees. With regard to the second issue relating to future prospect, it is found that the victim at the time of accident was a businessman and was aged about Mr. Bandopatya, age
You see, 48, 49 years.
40.
From the tax file or other document, you'll see 48, you'll see
48 years.
48.
Following the proposition of Honorable Supreme Court in National Insurance Company Limited versus Pranay Sethi and others, the claimants are entitled to an amount equivalent to 25% of the annual income of the deceased towards future prospect. Following the proposition in Pranay Sethi Supra, the claimants are also entitled to general damages of rupees 70,000 under the conventional heads of loss of estate, respectively. Other factors have not been challenged in this appeal. Bearing in mind,
Your Lordship deducted the income tax from 2,89,000. You see that income tax, your since I have not that document, Your Lordship, the amount of income tax that was paid.
It is in the 2006.
2016-17.
2006 is the
2006. So I'm making the calculation, Your Lordship.
Does the claimants are entitled to compensation of rupees together with interest at the rate of 6% per annum? Appellants are entitled 6% per annum from the date of filing of the claim application till
We have, my lordship, we have already paid the 6% per annum from the actual amount.
Wait.
Oh, my lordship.
In date of filing has changed.
3-3-16. 3-3-16. Nothing.
What date will be?
22-27.
Till payment. It is informed that the claimants have already received the amount of compensation together with interest in terms of order of the learned tribunal. Accordingly, the claimants are entitled to balance amount of compensation of rupees such and such together with interest at the rate of 6% per annum from the date of filing of the claim application till payment. Respond number 1, insurance company is directed to deposit the balance amount of compensation and the interest as indicated above by way of check before the learned registrar within a period of 6 weeks. Appellants claimants upon deposit of the balance amount and the interest as indicated above, learned registrar will rank the given shall release the amount in favor of a balance amount of compensation in favor of appellants appellants. After making payment of rupees 35,000 in favor of appellant number 1, widow of the deceased, towards spousal consortium within brackets since rupees 5,000 has already been received, bracket close, in the proportion that 40% shall be released in favor of appellant number 1 and the remaining amount shall be disbursed in equal shares in favor of appellant number 2 and 3. With the aforesaid observation, the appeal stands disposed of. The impugned order is modified. Order NCR to return. Right. Deal. Can the deal?
Second one. Oh,
My lord.
Deal can 1 of 2023. This is an application for extension of interim order granted on 13th July 2023. Mr. Shaturudriyo Mukherjee, learned advocate for the petitioner, submits for extension of the interim order. Here appearing Mr. Pal, opposite party number 1. Mr. Nobangpur Pal, learned advocate, appears for opposite party number 1. Next, Mr. Deboshi Dhar, here for oh, you are the caveator 1, and you are Mr. Kundu, opposite party number 2. Mr. Devojit Kundu, learned advocate, appears for opposite party number 2. Let the interim order granted earlier on 13th July 2023 be extended for a period of 3 weeks or until further order, whichever is earlier. Let the matter appear before the can dispose of. Let the matter appear before the next available circuit bench.
Highly obliged, my lord.
উনি কে এই যে এসছিলেন ভদ্রলোক হোসেন বাবু তো একজন রেজিস্টার আছে উনি চেম্বারে আসতে পারেন বাস
সুবিধা তাহলে কালকে